We're ready when you are, Chair Diaz.
All right, good morning, everybody. We're going to go ahead and call the meeting to order. First order of business is for Ms. Baker to do the public disclaimer and roll call.
Good morning. Notice of the November meeting of the Real Estate Commission, including date and time, has been noticed on the Tennessee Real Estate website since September 15th, 2023. Additionally, this month's agenda has been posted on the website since Wednesday, November 6th, 2024. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. I will now call the roll. Chair Diaz.
Here.
Vice Chair Ferris.
Here.
Commissioner Moffitt. Commissioner Begley. Commissioner Torbett. Commissioner Gwynn. Commissioner Tucker. Commissioner Smith.
Here.
Commissioner Gahn.
Here.
We also have a stenographer with us today, Ms. Ailes, and she'll be presiding, or excuse me, she'll be conducting or notating minutes during the rulemaking hearing today. Chair Diaz.
Thank you. Next item is for the prayer and pledge, and I will ask Commissioner Ferris to lead us in both, please.
Thank you, Chairman. Let us pray. Dear Lord in heaven, thank you for this day. Thank you for your hand in our lives. May we pause ourselves daily to recognize both your compassion and mercy to us and your providence in the world's doings. May we give you all the glory to that. Thank you for this state of Tennessee. Please be over our proceedings today and every person here, both in the room and listening. Thank you for our country, and may we always look to you every day. Since in Jesus' name we pray, amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Bless you.
Bless you.
Allergic to the pledge. All right, good morning. Next item is the approval of the agenda. I do have one change I'd like to make. I'd like to move the commission discussion to occur after we approve the minutes and before we begin informal appearances. I want a specific topic. I would like council to review the Fresh Start Act for our purposes this morning. So I will make that motion. Is there a second?
Excuse me, Chair Diaz. I would also like to add one additional informal candidate, an informal appearance candidate, David Dixon, that it did not appear on your original
So that'd be
agenda
candidate,
that was sent.
that'd be candidate F then?
Correct. You all were sent his informal appearance, I believe, on Thursday or Friday by Denny.
Okay. So I made the motion.
One more thing,
sorry.
if we could also add to the commission discussion gift cards as well, in addition to the Fresh Start Act.
Okay. So any
That's-
objection to those additions? Is there a motion to approve the agenda as amended?
So moved.
Second.
I have a motion to approve the agenda by Commissioner Smith, seconded by Commissioner Ferris. All those in favor say aye.
Aye.
Any opposed? Opinion of the chair, the ayes have it. That motion carries. Next item is the approval of the minutes for last month's meeting. All commissioners were sent the minutes. Is there any changes to the minutes from last month's meeting? Hearing none, is there a motion?
Motion to approve. Second.
I I have a motion to approve by Commissioner Tucker, seconded by Commissioner Torbett. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Okay. Commission discussion. We want to dispose of the gift cards first?
Whatever you would prefer.
Let's do the gift cards.
Okay.
Thank you.
Okay, so we have, as you know, two different rulemaking packages that will be coming before the commission in the next 2 months. This rulemaking package that we'll have today is related to the temporary retirement statutory change that happened. Next month, we have the retrospective rule review edits that were following the department's review of a certain rules that we needed to amend. And one of the rules that we are seeking to amend is related specifically to gift cards. Gift cards are, the particular rule related to gifts and prizes can be found in your book on page 87. So in this particular, the rule amendment, what we're seeking to do is to add an additional paragraph, I believe it would be paragraph 2. Hold on 1 second while I pull this up really quickly. And essentially what paragraph 2 would do, it is going to be similar language to the language that is found in 6213-302B, which is on page 28. And so the new language would state that a real estate licensee shall not give or pay cash rebates, cash gifts, gift cards, cash prizes, or any similar cash-based incentive in conjunction with any real estate transaction. And so we had this conversation a couple of months ago when we originally approved it. But since then, we've had a couple of individuals I know that have reached out to a few commissioners. I've also had some individuals that have reached out to me, and we've heard from associations looking for additional clarification related to gift cards. So specifically, we've had questions related to gift cards, whether they can be used at open houses and whether gift cards can be used as closing gifts. So my question, I wanted to at least have the commission have some kind of discussion and weigh in related to what they believe gift cards, if it's a blanket ban on gift cards, if we're going to allow them to be at open houses, or if they're going to be allowed to be used as closing gifts. Now, my point of view in looking at the statutory provision, it states licensee shall not give or pay cash rebates, cash gifts, or cash prizes in conjunction with any real estate transaction. So I could see that being like a cover of a blanket kind of related to the gift cards. However, if we're looking at closing gifts, closing is at the end of a transaction. So I'm not sure if that's related necessarily to a real estate transaction. And so we've had a couple of people ask that question if whether they could do that or the other. Also, we have people that are generally confused why gift cards are considered to be cash. And I've made the same thing as I've said before, is that gift cards are a cash equivalent. So they are for a specific amount of money, and you can only redeem them for a specific amount of money. So if you give someone a gift card for $100, that is essentially $100. If you were to go to a restaurant, you cannot spend $105. That gift card, you have to add additional money to it. So that's why I believe that gift cards are the same as cash. And if you look in that statute, in this 302B, it does state that the Real Estate Commission has general rulemaking authority to regulate the practice of licensees regarding gifts, prizes, or rebates that are not otherwise prohibited by law. So you do have the flexibility related to what you would like to do. So I'm just opening the floor to ask what we're doing with gift cards. If what we have right now is enough, if that's what you believe. This commission in the past has blanketly stated that they believe gift cards to be the same as cash. So we have not permitted gift cards, but there still appears to be some confusion.
Commissioners?
Well, I'd be one that would say that gift cards are routinely given out as closing gifts at closing, which you might say is part of closing, maybe it's not part of closing, but I do know that gift cards are given out. I know gift cards are given to agents at open houses, and those kind of things. And I don't think those should be considered something as an inducement to getting business. It's a thank you for doing business, and it's a thank you for that agent coming to my open house. It's not really something that says, here's some cash to help me, to help my business out.
Yeah, I think the quid pro quo is important there. Is it, am I giving you this gift card because you agree to list your house with me? Or am I giving you this gift card because there's some kind of, again, a quid pro quo that do this and you get the gift card? I think that's, for me, the threshold in terms of why the gift cards are generally forbidden. So I don't think a closing gift rates and agents getting them at open houses, I don't think really rates, unless, again, there's a quid pro quo. And I would also say the only time that it would rise to us to decide is if there's a complaint.
Correct. There is, if there is a complaint, but we are amending the rules right now.
Right.
So if we're amending rules, I would like things to be as clear as possible. So it doesn't come back to you guys to have to interpret in that form or fashion.
Right.
And so my question would be, because I'm unfamiliar with this practice, when gift cards are given at an open house, what is the purpose if not to get an individual to list the property?
Most of the time, those gift cards given at an open house are usually at a broker's open house. So that would be, if I had an open house and I only invited other agents, then they understand that they might get an option, they might be able to have a drawing and win that gift card. And they give us input on what they think the house is like, what we can do to make the house better to sell. So I don't know that we're paying them.
Okay, so it would just be come to the broker open house, and anybody that comes to the broker open house is entered into a drawing, and that person receives the gift card, but there's nothing attached to it so that the person is required to list the house.
No.
The house is already listed.
Right, the house is
So-
already listed.
Right.
Okay, that's a very good clarification related to that, because I think when we look at the rule, it says inducement to the purchase, listing, or lease. And so if it's an open house and the process is already listed at that point, I don't necessarily would see it as an inducement to a listing.
They also do them in open houses and do the same thing for people that come to an open house in order to attract more people to come to the open house, so you're not wasting your time doing an open house. You're trying to get as many people in to see the house as you can, and they'll have a drawing the same way for someone else to come in, with the public to come in. They'll have a drawing with a gift card as a giveaway, but it's not an inducement to, let me list Steve's house, I'm giving you this gift card. It's more of how can I get more people to my open house?
It's more of a thank you instead of an inducement.
Or marketing expense.
It's marketing.
How much are they? Like less than 1,000 or?
Oh, God. He is
Nah.
not in our world.
But it's still, in my mind, it's still inducement.
Right. So I think that I see I'm fine mostly with open house brokers, open house gift cards, and gift cards as closing gifts. But when it comes to the public getting gift cards at an open house for attending an open house, I feel like we get a little bit more dicey there, because it's from real estate licensee to real estate licensee. That makes more sense to me. But it's it talks about, inducement to the purchase, listing, or lease of real estate only if an offer is made. And so when we're giving it to, we don't generally give cash to people in period. So I don't know. That's just what I'm giving additional thoughts.
Is there a consideration for a dollar limit on the gift card going to the public?
No, I think dollar limits become very arbitrary and we don't know like where to stop and someone's going to contest. Yeah. If it's Commissioner Glenn, it might be a little high. No, I'm just kidding. But so I think setting a limit would be difficult to justify, why we've set it at $1,000, $150. What's the difference? At that
Well,
point.
let's be clear on one other thing. So in that situation, in Mike's situation, where if I host an open house for the public, but I have a gift, but not a gift card,
Right, gifts are still permitted.
Okay.
You just have to give the individual, the requirements listed in writing, what it is, fair market consideration, time and place and delivery, and requirements related to the gift. Now, a gift card is different than a gift
Right.
because we see gift cards as cash.
so if I've got a fruit basket
Yep.
sitting there, I'm good.
Right, you just need to follow the requirements for
Okay.
regular gift disclosure for that. So, unless I'm hearing anything differently, what I would do is that when we have our rulemaking hearing next month, because that would be the time that we can do amendments, to possibly add an amendment permitting gift cards for brokers, open houses, and as closing gifts.
So you're going to use those words precisely?
Right.
Okay.
And we can change whatever the language, it'll be reviewable at the hearing next month. And if we need to make tweaks, we can do that then.
So I know, excuse
If,
me.
if an agent gives a closing gift, whether it's a closing gift or not, gift card, they're okay as long as they call it a closing gift.
The person wouldn't be able to advertise that if you close with me, you get
Right.
X, Y, and Z.
Right.
Right,
I'm just saying
so-
at closing, they could be for other
Right,
reasons.
closing gifts could be other,
Yeah.
with the gifts and prizes rules, we're not changing that. It would just be specifically related to gift cards.
So one other aspect of that in terms of closing gifts, I don't know, sometimes there's a problem with the transaction, or there's something that was not conveyed with the property or things like that. And Joan, I think you have a case sample about that, where the gift card is not given as a closing gift, but it's given to kind of smooth the transaction over and allow them to, I don't know, acquire things. Commissioner Smith, go ahead and give your scenario.
My scenario on the refrigerator?
I would say the answer would be no for a gift card, because at that point, it would be related to a real estate transaction directly, because the transaction is still ongoing. Now, if it was a specific gift, like you said, like a refrigerator, of course, that would fall into the gift, requirements, and you can look at it that way. But like a gift card in that instance, I don't think that would be appropriate.
Which one are you talking about, my refrigerator or my cook stove? Which one you want?
Either one that would kind of clarify what I'm trying to say about how you deployed a gift card, or a gift card was deployed.
We had a situation where someone had promised a cook stove and then reneged on it, and it was an issue, so I bought a gas cook stove.
You purchased a stove?
I did.
That is fine. It's not a gift card.
No, it was a nice gas range.
Okay.
But
So-
everybody if you're a real estate agent, you've done that before. We have all
Right.
bought something.
Okay.
But how did you get it? Did you have it delivered to them, or did you
I
give
had it
them a
delivered to
gift
them.
card from Lowe's that gave them a
No,
deal?
I gave them the,
I see. I misunderstood. I thought
no.
the gift card, okay.
Yeah, okay, so that's what I'll do for the meeting next week. I just wanted to get some clarification because I promised next month, oops, no, I won't be here next week. I'll be at a different meeting next week. So we'll do that related to the gift cards for next the next meeting. I just wanted to have the discussion because a lot of people are asking to have said discussion. So I thank you for your thoughts. And I guess we'll go now to the Fresh Start Act.
Yes, I know you're pleased, Anna. Thank you.
Yes, I'm so happy to talk about this.
And I brought this topic up specifically because I think we've had a couple commissioners join us that maybe didn't hear Anna's dissertation on the Fresh Start Act the last time, and I specifically want to focus on the area of approval of applications versus denial of applications, and the battery of questions that the commission has to answer if a denial is issued for an application, and whatever recourse the applicant would have after a denial. So
Okay.
if you could focus on that, that'd be good.
Yes, and if you go to the last document on your iPad, there is a copy of the Fresh Start Act there, so we can your iPad, that you can follow along there. So also the great thing about this document on the iPad is that it has a little bit of a red line information because there have been changes related to the Fresh Start Act since we originally had it presented to us. So essentially, if we are looking at an application for approval or an application for a renewal and we decide to deny an applicant due to their past criminal convictions, there are certain things that we have to do and consider prior to making that decision. Now, the commission is not stripped of that power of denying an individual licensure or renewal due to a criminal conviction. That is still 100% on the table. There used to be a rebuttable presumption against Class A, B, and C felonies if an individual was on, I believe, the Animal Abuse Registry or Sex Offender Registry. Those presumptions are no longer in place. So we're looking at any really types of convictions. So if, for example, I came before you and I had been convicted of one of our criminal convictions that we review, which at this time are all felonies or any misdemeanors related to theft, money, or property. And based on whatever circumstances you decided that I would not be an individual eligible for application at this time and you were to deny my license, that is possible. But there are a couple of things that we need to do to let that individual know why their application is being denied related to that criminal conviction. And so if you look on the bottom of the first page, you'll see that we would have a discussion related to what is written in A, the relationship between the nature of the crime and purposes of regulating the profession. B, the relationship between the crime and the ability, capacity, and fitness to perform the duties and discharge responsibilities of the profession. C, any evidence of rehabilitation or treatment undertaken by that individual that might mitigate against the relationship of the crime. And then D, any applicable federal laws regarding an individual's participation, occupation, profession, or business or trade. Now, there used to be 6 factors that we have to go through, and now it's been reduced to 4. And so if you were to deny an individual based on a criminal conviction, then we would have a discussion where I would talk to the commission, give you a prompt of each of those. We'd have a discussion about it on the record, and then afterwards, that individual at the meeting is, and if we look at B2, at the last sentence, it says that prior to denying the application, the individual has to be sent written notification that includes the licensing authority's justification for denial or refusal and renewal of a license. And then the determination must state the earliest date upon which the applicant is eligible to reapply for license certificate or registration. So in our particular case, it is 6 months because that's written in our rules in 1260-01-.01. So we would just send an individual a letter letting them know that their application has been denied related to that. Now, the recourse an individual has is found in subpart C. It says an individual applicant or licensee who receives written notice may file a petition within 30 business days of the receipt of the notice in Davidson County Chancery Court. And then that licensing authority, at that point, we must demonstrate by the preponderance of the evidence that the individual applicant, licensee, certificate, or registrant's conviction is related to the applicable occupation, profession, business, or trade. So that's their recourse is through Chancery Court, if that were to occur. Now, the one thing I do want to say that is separate from the Fresh Start Act is that we do have individuals that appear before this commission related to any kind of discipline from occupational or professional licensing, related if it's at the state, federal, or local level. That does not fall into the Fresh Start Act. So if we were to deny an individual, for example, because their license had been revoked in Colorado, you can still revoke that individual's license. It does not fall into the Fresh Start Act, so we don't have to go through the factors. We don't have to send that individual that letter where letting them know of whether the conviction is, related to that. So there are those two categories in which those things kind of fall into. So any questions? Yes.
So on the notice,
Yes.
if we deny someone in a meeting,
Correct.
they're really not denied until they get the letter? Is
So
that-
no, they would be denied at the meeting. The letter is essentially notification, letting them
Notification.
know, official notification of the denial. This commission, in my experience since I've been here, I have had to send, I believe, just 1 or 2 letters to individuals that have been denied based on criminal convictions. We've had a couple of other individuals that have been denied based on occupational disciplinary action from other states. But I've only had to send out 2 of those letters. That's only in the past we've been here.
So they have 30 days to get the letter?
The letter would essentially be sent out, for me, I think the time period is pretty much immediately. It doesn't, there's
Okay.
not a specific one, but they have 30 days, 30 business days upon receipt of the letter to file a petition for reconsideration in Chancery Court if they want to appeal your decision.
And this letter is sent certified?
The letter, yes, we send, it'll be sent certified, regular US mail, and via email.
So you know when the days start counting?
Right.
Okay, thank you.
Any other questions about the Fresh Start Act? And, all right,
So just
ahead.
to be clear then,
Right.
make sure I got it. It doesn't apply to previously licensed real estate licensees, correct?
Previous-
Whose license may have been revoked.
So the revocation, no. In that circumstance, if they're coming to you because of a revocation related to occupational state licensing, it would not apply to you because it is not a criminal conviction.
Got it.
So, and to the informal applicants waiting online, this is no indication about how we're going to vote or how things are going to pan out during today's hearing, but we just wanted to make sure the commission had all the information going forward. Any other questions for Anna at this point? In that case, thank you very much, council.
One more thing I would say, it's sort of kind of related to this. If you ever have any questions related to the Fresh Start Act or anything related to the commission, please feel free to reach out to me and or Denise. Just a gentle reminder that any questions or comments that we have related to board business should only be during the board meetings. Anything outside of board meetings would be a potential violation of the Open Meetings Act, and we don't want that to occur. And so that would be with 2 or more people having board discussions. Usually every year we give a refresher on the Open Meetings Act, Public Records Act, and North Carolina Dental, the anti-competitive matter. So we won't have that this year, but we will have it again next year, just as a reminder to everyone. So that concludes this portion of my talking.
Just one other thing, Anna, can you, I know I would want it, does all commissioners want this statute for reference in case they are reviewing cases in the future and they want to prepare to answer the battery of questions?
We can email it to you. We'll email it to you after this meeting.
Thank you. All right, with that done, that takes us to our informal appearances. Do you want to do a roll call of them?
Yes.
Ms. Baker?
Good morning. Thank you all for your patience and for those here for informal appearances. I just want to make sure that all the candidates here for informal appearances are here with their broker. Briefly unmute, bless you, briefly unmute your mics and say present to make sure you and your broker are here. The first candidate will be Carrie Elmore and their broker Phyllis Sissom. Are you all
Here.
present?
Yes.
Thank you. Kiera Medlock and broker Cheryl Hines.
Harrison. Here.
Thank you. Next, candidate C will be Michaela Bruno and broker Christopher Claybaugh.
Present.
Present as well.
Thank you. Next, we have candidate D, Crystal Kemp and broker Dwight Price.
Present.
Present.
Okay. For your informal appearance, we request that your camera be on.
We're having trouble. We've tried everything we know to try, and we can't get it on. We'll continue to work.
Okay, next to the mic button, there's a camera button. And if you're using a PC, I would recommend, if your computer has one, sliding the tab to the side to uncover your camera. Sometimes that works as well. Next, we have candidate E, Joshua Young, and principal broker Ashley Mullins. Are you all present? Joshua Young and principal broker Ashley Mullins.
Present.
Okay, perfect. Thank you. Lastly, we have, and this is the one that we added, David Dixon and principal broker Charles Johnson.
Present.
All right, and I believe attorney Cole Braun is on the line with us as well. Is that correct?
Present as well.
All right, thank you. Everyone's here, sir.
Okay, thank you, Ms. Baker. Go ahead and tell us about candidate A.
Okay, would you like to give an overview for the
You're
process
right.
for everyone?
That's right. Thank you. So the way informal appearances work is that we will first hear from the applicant. Applicant will explain the circumstances that caused them to appear before us today as briefly as they can. After your statement, the commissioners will be given an opportunity to ask questions if they have any. Once that finishes, then the broker will be able to explain why they want this particular applicant to join their firm. And again, the commissioners will have an opportunity to ask questions. After that, the commission will then vote, and we will get the result of your application at that point. With that done, we'll go ahead and hear about candidate A, please.
Candidate A is Carrie Elmore with principal broker Phyllis Sissom, and if I'm mispronouncing your name, I do apologize. He is before us today due to a felony possession of a controlled substance. He has taken and passed the timeshare salesperson exam. You will find the statement, his statement and letter of recommendation on your iPads.
Thank you. Mr. Elmore, please go ahead and unmute your microphone and explain the circumstances that bring you before us today.
In 2016, when I was 19 years old, I was in college and accepted an offer to basically sell some marijuana. I was pulled over and arrested with that marijuana and charged with that possession. I did my mandated time in jail. I completed my probation with no issues, and I haven't had any issues with that since.
Thank you, sir. Commissioners, any questions? Hearing none, Ms. Sissom, please unmute
I
your
have
mic.
no questions. Huh?
Go ahead, please.
Well, we would like to, he's been showing up for work. He's like all excited. He wants to get his fresh start and he wants this behind him. And he was young, dumb, and in college doing a dumb thing.
I was, yeah.
Thank you, ma'am. Any questions for Ms. Sissom? Hearing none, is there a motion?
I move to approve.
Second.
I have a motion to approve this application by Commissioner Gahn, seconded by Commissioner Ferris. Any further discussion? Hearing none, let's vote. All those in favor of the motion say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, sir, and good luck.
Thank you.
You're free to stay and listen to the rest of the meeting or to disconnect and go about your day. Thank you.
Thank you so much.
Thank you.
Ms. Baker, candidate B.
Candidate B is Kiera Medlock and Principal Broker Cheryl Hines. She is before us today due to a felony false impersonation. She has taken and passed the affiliate broker's exam. You will find the statement and letters of recommendation on the iPads.
Ms. Medlock, please go ahead and explain the circumstances that bring you before us today.
In 2015, I wrote a bad check to Cisco. I was owning a restaurant. And at that time, I wasn't aware that the account was closed. So I done my 3 years of probation, completed that, and since then, I haven't had any issues. I work for State Farm as well now, and I run the tax business as well. So I learned from my mistake back then, but it's been 7 years, and I haven't had any issues since then.
Okay, Commissioners, any questions for Ms. Medlock? Hearing none. The broker, if you could unmute your microphone and please tell us why you would like this applicant to join your firm.
I have known her for a few years, and in my interactions with her, she's a very enthusiastic person, a hard worker. Like I said, at the time I met her, she had 2 restaurants going, food truck, an insurance agent, and was doing numerous things, raising 2 children herself, and just a hard worker. And I just feel like she, carrying out her probation period, being sorrowful for the act and really, not aware of it at first. But anyway, it seems like a hard worker, and I feel like that she'd be a dynamic real estate agent and an asset to the Tennessee Real Estate Commission.
Thank you, Ms. Harris. Any questions for her? Hearing none, Commissioners, is there a motion?
Move to approve.
Second.
I have a motion to approve by Commissioner Gwynn, seconded by Commissioner Torbett. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, ma'am, and good luck.
Thank you.
Ms. Baker, candidate C.
Yes, we have Michaela Bruno and, bless you, sorry. We have Michaela Bruno and broker Christopher Claybaugh. She is before us today due to a misdemeanor theft charge. She has taken and passed the timeshare exam. You will find the statement and letters of recommendation on your iPad.
All right, good morning, Ms. Bruno. Please unmute your mic and explain the circumstances that caused you to be before us today.
Yeah, absolutely. So I've never been in a position like this. I've never stolen in my life. That was my first ever charge on my person. I completed 16 hours of community service, and I would never put myself in a position like that ever again. I was getting groceries. It was a normal trip, and some of those items were not scanned. I did offer to pay, and that was refused. But like I said, I completed the hours out of my own free will. It wasn't mandated by the court. I did that on my own, just to show that I guess that I wasn't putting myself in that kind of a position ever again.
Thank you. Commissioners, any questions for Ms. Bruno? Hearing none. Mr. Bruno, sir. I'm sorry, Mr. Claybaugh, sir.
Yes, she has already passed our internal background check. She has done our 2-week training program, and she's excelled through those, and we're excited for her to be part of our team.
Thank you, sir. Commissioners, any questions? Hearing none, is there a motion? I have a motion to approve by Commissioner Tucker, seconded by Commissioner Moffitt. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations, Ms. Bruno, and good luck.
Thank you.
Thank you.
Ms. Baker, candidate D.
Next, we have Crystal Kemp with Principal Broker Dwight Price. She is before us today due to a theft charge. She has taken and passed the affiliate broker exams. You will find the statement and letter of recommendations on the iPad.
Okay, Ms. Kemp, please unmute your microphone and explain the circumstances that caused you to be before us today. Ms. Kemp? Please unmute your microphone.
If you would like, we can go to Joshua Young and Ashley Mullins and see if they work out their technical issues.
Thank you. Candidate E, please.
Okay. Next, we have Joshua Young and Principal Broker Ashley Mullins. He's before us today due to a theft charge. He has taken and passed both affiliate broker exams, the national and the state exam. You will find the statement and letter of recommendation on your iPad.
Mr. Young, please unmute your microphone and explain the circumstances that caused you to be before us today.
Good morning. Thank you for giving me the opportunity to speak before you all. In 2016 to 2019, I made some bad decisions after my divorce. Went down a path I shouldn't have. Since then, I've finished my probation, finished all the requirements y'all have asked of me, and I'm just trying to right the ship. And thank you for the opportunity. It's a blessing indeed. Thank you.
Commissioners, any questions? Hearing none. Ms. Mullins, please unmute your microphone and tell the commission why you would like Mr. Young to join your firm.
Morning. Thanks for allowing us to be able to speak today. I am a close relation, not only professional, but personal wise to his family. And I have seen him over the past 5 years really become very close with his family, very supportive of his family, be gainfully employed for several years now, and very active in his church. So I have no hesitance in allowing him to hang his license with our firm and become part of our real estate family here.
Thank you, Ms. Mullins. Any questions for her, commissioners? Hearing none, is there a motion?
Motion to approve. Second.
I have a motion to approve by Commissioner Torbett, seconded by Commissioner Tucker to approve this applicant. All those in favor say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Good luck, sir.
Thank you.
Thank you.
Ms. Baker, candidate F, please.
Okay, next we have David Dixon with Principal Broker Charles Ashley Johnson. He is before us today due to a revoked Tennessee real estate license. He paid the civil penalty associated with his revoked license in the amount of $1,280. He paid that on October 31st. He has taken and passed recently both the national and state broker exam. You will find the statement and letter of recommendation on your iPads, and his attorney, Cole Braun, appears before us today as well.
Thank you. Before we get to their statements, I just wanted to ask questions. So his license was revoked
His license was revoked, I believe, in 2011.
2011, and that was because,
I believe it was an earnest money violation. If you read the statement on the iPad,
You're right.
he attests to misusing earnest money funds when he was licensed once before.
okay.
I believe it was 2 different instances where he misused earnest money funds.
So, and he's seeking to reinstate a broker's license?
That is correct.
No, I actually believe, I'll
Or
let
or is
them-
or is he
I'll let
retesting and
them
reapplying
speak.
for an affiliate license?
I'll let them speak before, but I believe if you look in the letter sent to the commission by Mr. Braun, he is looking to be actually an affiliate broker at this time. I think that they refer to it as associate, but that, I believe it's affiliate broker.
He did, however, take the broker exams. And I will say the requirements exceed what an affiliate broker needs to test at. So an affiliate broker must get a 70%. A broker must maintain a 75% to be issued a license in this state.
Okay. So I guess for me, is it when his license was revoked, that license went away?
Correct.
Right.
So we're not resurrecting that license?
Yeah, so if you look at the letter from Mr. Braun, I believe that's on the second page. And if we look at the third paragraph towards the end, it says the safe handling of escrow deposits received from the client and potential purchasers is of utmost importance, and the commission should take notice that Mr. Dixon will be acting as an associate broker only with supervision and assistance by an established and respected broker, Mr. Johnson with the Realty Group. And then also Mr. Dixon mentions that he will be in the answer to number 8 on his question, which I believe is on page 11. And it says, to avoid any future issues, I will be working as an associate broker at the Johnson Realty Group in Sevierville. So I'll let you ask them specifically what license that it is that he's seeking to reinstate, but there is at least 2 instances in the documents we have before us where it looks like he'll be working with a broker. And if you have any questions about like the specifics of what the particular underlying issue is, there is a copy of the order, the final order from the formal hearing that begins on page 12. And it has the complaint information and any additional facts. So the initial judgment was revocation and then additional fees to be paid to the commission.
Okay. So, and we'll hear from them, but if this turns out where he's just applying for an affiliate license,
Right.
then this is a simple matter of us deciding whether or not he can proceed and get issued that affiliate license, and he'll be under the supervision as required by other affiliates.
Right. So I believe the commission has the ability to give either license. You know, if you would like to give a broker license, if you would like to give an affiliate license, that is up to your discretion.
Okay. All right. Thank you, counsel. All right, Mr. Dixon, please unmute your microphone and.
Yes, sir.
And go ahead and clarify for us which license you are seeking with us, and explain the circumstances. Otherwise, that would cause you to appear before us today.
Thank you. Good morning, Mr. Chairman, Mr. Vice Chairman, Commissioners, and Council for the Tennessee Real Estate Commission. I want to thank you, first of all, for this opportunity this morning to address my application decision regarding prior disciplinary sanctions against my broker's license, number 254008. In 2013 and 2014, I made 2 very bad decisions regarding clients and my escrow account, which caused the revocation of my broker's license. It also cost me everything I'd built to that point in my life regarding my morals, honor, and self-worth as a man and business leader. As a young man having the honor to have served my country as a sergeant in the United States Air Force, I thrived on the code of conduct and honor. I was awarded 2 Air Force Achievement Medals, Combat Readiness Medal, Armed Forces Expeditionary Medal, and Air Force Good Conduct Medal. What my country had seen in me was the very fiber in which I was raised. Those 2 bad decisions do not reflect my morals or ethics, nor do they define the person I am. However, since those days, I've tried to correct those wrongdoings by living my life as a better person. I've donated my time to several charitable foundations, The one closest to my heart is the Sevier County Food Ministry, where I volunteered for almost 4 years, now serving an average of 1,000 families per week we feed. Through this organization, I've appreciated the simplest things in life. As their motto says, working as one for the good of many. And by that creed, I want to once again share my knowledge and expertise to families that have been wanting to reach the American dream and to own a home or business. I know I have a lot to give back, and through being a realtor, once again, I can assist in achieving those goals for many. In closing, I humbly ask that you give me an opportunity to serve my community as a licensed broker for the state of Tennessee. Thank you. Any questions? I'll be glad to try to answer for you.
So I might take from your statement then, sir, you would like us to reinstate a broker license for you?
Mr. Chair, when I originally came back to attempt this process, they asked me to go online and I had to, through the TREC, go through and identify my information to be able to have the ability to ask for my license back. So when I did that, it defaulted me back to my broker's license of 254008. So from that point, because of that, I just worked, forward through the process and completed everything that was asked of me to be completed through your real estate commission. So I was asking, yes, for my real estate broker's license back, but strictly as an associate broker to be under Mr. Ashley Johnson as the principal broker.
Okay, sorry, counsel again. So if we issue him a broker's license, then he has the full rights and privileges of a broker.
Yes.
And we can't curtail it anyway.
You can issue him a broker's license or an affiliate broker's license.
Okay, so there's no watering down of a broker's license. Okay. Thank you. Mr. Johnson, it's your turn. Please go ahead and explain
Yes, sir.
why you would like.
Yes, sir. Thank you for having us. I've known David professionally for a short time before this incident occurred and his license was revoked. But then I've also known him as a friend and member of the community here in Sevier County for the last almost 15 years, I guess, 10, 15 years. David's got a real passion for real estate. He's continued to have passion for it. I've talked to him quite a bit about different developments and deals that I have going that, just he has a deep knowledge of it, of real estate and of our industry. He enjoys it. I think he would thrive back in this situation. I actually helped encourage him to go through this process so that he could get back into doing what he really truly loves. Like I said, I've known him and his family for quite some time. He's got great girls. He's raised a beautiful family. They've prospered. That's credit to him and his wife, Liz. He would be under my supervision. I've got a very strict policy on how I handle earnest money. We don't even put it through our escrow account. It goes directly to whatever title company or law firm that's handling the transaction. So we don't, and we have escrow agreements in place. So that's how I handle those issues internally, because I don't ever want to have an issue with it. I know that in my conversations with David, he's very remorseful, very regretful that he made these decisions and just would like another opportunity.
Thank you, sir. Any questions for
Yes, sir.
this broker? Here, I do have more questions again for counsel. Do we have the discretion to, let's say, issue an affiliate license here, and then if we issue the affiliate license, he would have to wait the statutory 3 years before they could upgrade to broker?
I mean, if you were to issue an affiliate license, it would be the same requirements as all affiliates, so yes.
And that's statutory? Do we have discretion in there?
I mean, I think you have some discretion, but generally when it's an affiliate license, as anyone else that would come forward, it would be the 3 years and then the post 120 within the 3.
Right. So But you tell me that his education, he's already taken the broker's exam and he's done all that work already?
Right, so if he's already taken that, like, it would,
The clock starts over.
right,
clock
so
starts over.
essentially, it would not, the information, the stuff that is, sorry, unprofessional. The requirements.
It's all the sneezing.
It would be the same, would fall into the same amount of time which that information, which it is good
Okay.
for, so, yes.
Okay, so yeah, so the results on his broker exam that he's already done would expire before he could upgrade.
I believe so.
The test, as of today, the tests are good for 6 months.
The
So-
testing,
I see.
now,
Yes.
education, not necessarily.
So testing's good for 6 months, okay.
Yeah, the testing is the issue.
All right,
I've got a question when,
go ahead.
so Anna, on the previous, back in 2015, the case with the Real Estate Commission headed by John Grease, the sentence that says respondent's license shall be permanently revoked.
Correct.
What does that mean?
Permanently revoked, that's same language that we use everywhere. Like, generally, we will put permanently revoked, but permanently, we can't permanently revoke someone's license. As we mentioned, I think it was
You
last
cannot
month,
do that?
you can revoke a person's license, meaning that license no longer exists, but like forever, for all time, to my knowledge, no, you can't do that because
Even though
it's-
that's what it says?
yeah, sometimes errors occur. But if we remember, I think we talked about this last month, that, occupational licenses or any license are considered to be like a property right, and so we can't permanently remove an individual's property right. So the commission has the discretion, if we were to deny a license for 6 months, you can deny a license, but like a license you can't say, to my knowledge, and I'll clarify, you can never have a real estate license ever again in the state of Tennessee.
So today, if the same case came before us, would we not use that same language, or we wouldn't?
I personally wouldn't use permanently revoked,
What would you-
but that
what would you-
is.
how would you
I
say
would
it?
probably say that the individual's license shall be revoked. And then, so that's the language, I believe, I think it's Miss Ryan that wrote this there. And then typically, whenever an individual's license is revoked in my orders, I would include the requirements of what it would take for that person to reinstate their license. So it's just really a term of how this order was particularly written by this attorney.
So do you think this is a subjective question maybe, what do you think was going through the commission's mind when they signed that?
I think it's just revocation. I think
okay.
period
All right.
revocation is what the commission issued at that time. There's nothing for me to otherwise believe that it meant for all and ever.
Okay.
But I have seen the language permanently revoked before in other individuals' how it's written, but that is not something that I personally would use.
All right, so, Mr. Dixon, I guess the question becomes, what's your pleasure, sir? Do you want us to consider a broker's license, or do you want us to consider an affiliate license?
I have a question.
Oh, I'm sorry. Hold on, Mr. Dixon. Go ahead, Commissioner.
I have a question. Talking about the $25,000 that was paid through that the commission paid, so through the education and recovery account. So my question is, was $25,000 paid back to the man that gave you the earnest money, and then the commission paid the additional $25,000? Is that what I'm reading here? It's $50,000.
Right, I'll let Mr. Dixon fill in on the amount that was repaid, I believe, to Mr. Patel, but I am unaware of payments made from the real estate education recovery account.
What page are you seeing that on?
It's on,
So Anna, You just said you were unaware of 25,000 being paid from the recovery account to a Mr. Patel?
That actually exceeds our limit.
Right, I don't have that information.
So, Mr. Dixon, did you pay 50,000 back and then additional 25,000 back for two separate instances to these individuals?
Chairman, I did pay the $50,000 back to the first the first complaint. The second complaint I did not pay back, but my understanding that the recovery account paid $15,000 of it. I think that's the maximum allowable. But no, I did not pay the $25,000 back. I did pay the $50,000 back.
So was Mr.
but
Patel
not
made
the-
whole for his 25,000?
Well, the 50,000 was made whole for the first one. The second, Alpesh Patel, was not.
Right, I know. So it sounds like it's.
Yeah, there is. There's
Right.
the second at the
So-
time, because of it was only 25,000 that the recovery account paid 15,000, and then he, basically agreed to let the other 10 go.
Why did he
understanding.
agree to that?
I don't know. It's a very good question.
Was it?
So are we able to find out if that payment did actually get made from the recovery account?
At this time, this predates both of us being in these roles, so if you would like to continue this to next month, you guys can possibly waive the exam requirement because his exam does expire within the next week or so, but we don't have any knowledge of repayment back to the recovery account from 2015.
Let me see if I can send an email, an email to one of our accounting individuals to see if they have that, but I'm not aware of when I've been doing work with the recovery account, that amount being paid from an account, but I can see what I can find out during this meeting.
But he's saying he paid 15,000. He didn't pay it, so the man didn't get the 25,000. He may have got 15,000.
Right, so I'm saying, my understanding is that Mr. Dixon paid him 25,000, and then the 15,000, which is the cap, right, should be statutorily from the real estate education recovery account, would be the amount. The only thing is, I don't know if that came out of the real estate education recovery account. Now, that's not in the order of what has been particularly written for. Like, it's in the order and the facts, but it doesn't state anything in here related to responsibilities for Mr. Dixon. Does that make sense? So it states that at that time, his license has been revoked and that he is to pay X, like the $1,280.
Okay.
Well, I got a
And to
real
clarify,
problem.
I
He
did
didn't pay
know.
the $25,000 back. He said he did. I got a real problem with that.
Yeah, and I
Okay.
did not pay the 25,000. That's
Was there a criminal charge?
There was a criminal charge on the first offense, which was dismissed after
Yes.
the money was
Okay.
the money was there and escrow dismissed. And you all have that information.
Right,
The
that's on
second one was
page
never.
20.
Yeah, the second complaint was never. He never charged any type of charges.
Okay, thanks.
If you look at page 21, there's also a check for $50,000 to Mr. or the Patels. Don't know if that helps you or not.
That was to Bobby Patel, not Alpesh.
I've got a question on, and maybe we should hear from Mr. Braun, but the table of contents.
Oh,
Where is
there's
all
some of
that?
the information in the table of contents I did delete from it because because that is not information that you normally would get during an informal appearance.
So what's like an FBI background check? They just did
it's a
that for their
regular,
own?
right, so all individuals that come before us have a TBI and FBI background check that is done, and so he included that in the application. That information was not provided to you because we do not provide you with TBI and FBI background checks. That information is considered to be confidential.
Okay.
But if he had any issues on the background check related to criminal convictions or anything, that also would be before you at this time, but there are none. The
What
only
if-
criminal matter that was related to this was dropped, and you have that documentation in your packets. It's on page 20.
What about the dismissal order of criminal matter? Do we have that?
What
is
the
that?
document that you're looking at on page 20, if you look in the box over there, it says dismissed. It's
Okay.
checked.
I have a question.
Yes.
What has Mr. Dixon been doing for employment since this incident?
I'll be glad to answer that. When I lost my license, it actually was, I believe, July 2016. I spent some time trying to figure out what I was going to do since my passion was real estate for so long. But fortunately, my wife works at the University of Tennessee, Knoxville, and was able to support until I got on my feet a little bit doing marketing. I had several developers reach out to me and ask me, questions on locations and things like that of their properties and businesses, and so I helped do some of that. The last 4 years, however, I've been working and doing. We're getting ready to open a distillery here in Sevierville, Tennessee, which I've gone through the process, which is very, very tedious with the alcohol and tobacco tax, which is the TTB, as well as the ABC, that we've got our licensing to open for this next month. So I did go through those two licensings, successfully with the TTB, which is the Alcohol and Tobacco Tax and Trade Bureau, as well as the ABC. But I'll do that, starting the operations manager of that for which I'm part owner of, the second week of December when we get it up and running, and then we'll transfer into a new, other management as I hopefully will, be able to start back into real estate full time.
So, Commissioners, regarding the second payment of the $15,000 by the recovery account, I know that we all want to find out whether that payment was made or not, but I also want to point out that Mr. Alpesh Patel hasn't complained any further about him wanting to be made whole that we know of, and that the statement that has been made during this hearing that he agreed to accept that $15,000 as remittance, I think, should have some weight, even though there's a remaining balance of $10,000 that, most of us can't understand why he did that, but that's neither here or there. We have information that tells us he accepted it. So any questions about the remittance of that money, I think.
I'd like to just clarify something that I think may be missing here. The statement that we're all looking at is, I believe it's number 22, says respondent admitted he could not repay Mr. Andy Patel the $25,000 because, related to the real estate education recovery account. Like, that information is written in the facts that have come from the hearing. So that means that this is information that came from the hearing and was given. So if Mr. Patel did want to have that money paid from the real estate education recovery account, then they would at that time have to petition for that money to be done, to be made. And I'm not aware of receiving any petition related to that to those funds. So it's a fact that's in there. So facts are just like, a summary of what was said and occurred at the hearing. There's nothing in the order. It's not a conclusion of law. There's nothing in the order that states that Mr. Dixon was required to pay that money to him. If he did later, that would probably be something that, came from their outside decision making. But the particular judgment from this commission is that the license was revoked, that they would pay, the money would be paid, and the different fees related to the entry of the order. There's not a judgment that states anything about $25,000, $15,000 from Mr. Patel or from the real estate education recovery account. I wanted to clarify that is something that would be extemporaneous in this situation.
All right. Right, because we don't have the authority to require people to,
Right, we
Pay-
can't make someone make a claim to the real estate education recovery account
or compel somebody to pay back money they owe.
or money that they owe, correct? So if there had been a claim to the real estate education recovery account, which I'm not familiar with because we've looked, from my knowledge, we've not had a claim in a while from it, we would have known about that and it would be, but I don't know of one that came out from, or as a result from this.
So Mr. Alpesh, Andy Patel, he was made aware of his ability to apply to the recovery fund.
It is, he could, I don't know if he
Don't
was
know.
made aware, I wasn't here, but
Right.
I'm sure that someone would have at least told him at that point.
Okay.
I got another question.
Go ahead, Commissioner Quinn.
Anna, what was dismissed? I hate to get bogged down. Was this it says criminal court.
You're on page 20, the
Yes.
offense, which was
So this was.
there was a criminal charge related to it, and this particular one on the form that you're looking at is worthless checks from $10,000 to $60,000.
So this was a district attorney, right?
So this judgment is a criminal. It came from the Criminal Circuit Court for Sevier County, and it was dismissed.
So,
There's no
so
conviction.
what was dismissed was a case filed by the district attorney
Correct.
against
Against Mr. Dixon.
Mr. Dixon.
Yes. So
Okay.
sometimes,
Yeah,
when we
this-
have individuals that have issues that may have, there will be simultaneous criminal charges if there is an issue here. But this one, there was a offense that's listed, if you look here, it's for a worthless check between $10,000 to $60,000, but it was dismissed. So we don't have conviction for that.
I know there's yeah, right.
Right, yes. But it is in conjunction with this case, but it did not move forward.
But that appears to be for the first incident.
Right.
So the second incident doesn't look like there was criminal charge. It seems to have just kind of gone away, honestly.
The district attorney has the discretion to decide which cases they choose to bring, and so it may have been that they just, I can't speak for them, but there was just the one.
The first charge was this is David. The first charge was dismissed because of the fact that I paid back the $50,000 and both the plaintiff, district attorney, as well as the judge, they all agreed to dismiss the charges at the time since the $50,000 was paid. That's basically why it was brought against, to begin with. That's what he wanted, was his money back. I understand that, and it's sitting in the attorney's escrow until the trial came. So, but on the second one, Mr. Alpish, I was never charged any criminal charges for worthless check or anything for Mr. Patel. And he's just, I assumed, of course, we all know what that means, but I assumed it was, he was made whole and just taken care of as far as for the recovery fund. But I don't know. I know it was offered to him. So
Commissioner.
what I would also like to,
Go ahead, Mr. Dixon.
I'm sorry.
Go ahead, sir.
I'm sorry, Mr. Chairman. What I would also like to say, and I think is a little bit of a misunderstanding, probably on my part, as well as talking to the commission at the very beginning stages of this to get, get my license reinstated. I thought they told me to go on, and that's what I did. So through the process, it just evolved into the brokers, and that's why they sent me, the things to do and the things to take, and I did everything that I completed. If the commission, I humbly asked the commission, at least, I would certainly understand if you all went ahead and just approved the affiliates broker's license and then let me go through the 3 years to prove, what I'm here to tell you that I will prove that I'm ready to do, obviously the right thing. I had my license since 1994 and then got my brokers in 2000 and and bought a company in 01. And, up until the 13-14, I had not had any type of complaints or anything like that. So I'm just, I'm at the mercy of the commission for this. Thank you.
So I guess in constructing the motion, commissioners, we would just need to say that we are allowing Mr. Dixon to proceed to get an affiliate's license, or if we wanted to allow him to have a broker's license.
Yes.
Okay.
Go ahead, John.
I think whether the commission, whether we paid him 15,000 or whether the fund did or didn't make any difference. He stole $25,000. I mean, that's 25,000. So the 15,000, if he was paid out of the recovery fund, that don't make any difference. He stole $25,000. That's my opinion. And I don't think he needs to touch money.
Commissioner Ferris?
I recognize that the findings of fact from 2015 do not, would not and would not have said, Mr. Dixon has to pay anything back. That would be for a court of law, and I realize that was not brought to a court of law. But I am just curious, Mr. Dixon, of the relationship then and now with Mr. Andy Patel, as to why. I mean, did he feel like you deserved that $25,000? Did he feel like you were owed that for having gone, as your attorney states in his letter, that a family member had gone behind the deal and done the deal? Or what's the story there? I don't understand, and perhaps I'm just not listening better, but I'd like to just hear more of that story. And what else can you share, Mr. Dixon? Thank you.
Well, through, many years since I've been in real estate and in this community, I mean, I've dealt with numerous, developers, investors, regardless of what nationality they are. But, and in that nationality, I've got a really, stellar performance past with probably 75 to 100 of the India residents. So, I don't know if it was, one of the relationships between, another party that I dealt with prior to, they let it go. Honestly, I never did follow that. He's not from our state. So, this was one that, that I only dealt with once, obviously, but the family members in the area, I don't know if they reached out to him or not, or just, I don't know. I can't attest to that. I have no, there's no proof or anything that I've known, and I don't, not proof, but what I'm trying to say is I don't know of anything that he was given restitution or not. But evidently, I assumed it was through the recovery fund, because I never heard from him again. So that's the only thing I can go by.
Thanks for sharing that. I mean, I think we do find out about this recovery account, whether or not it was paid, just that, we talk a lot about that account from time to time, and to know it's, you know, I know there's a significant amount of money there, but I do know it's under our purview to know what's going on there, but that's aside.
Just to let you guys know, this was a last-minute addition, so we didn't have a moment to do our due diligence in reference to the recovery account and if that money was paid. But
Yeah, I
that is
want to be.
something that we could look into.
Thank you, Denise. I want to be respectful of Mr. Johnson, Mr. Dixon's time, as well as your attorney. Part of me is inclined to try to move forward with this today if we can, but anybody else have any thoughts? Steve, you got any thoughts?
Commissioner Torbett, hold on.
I have
hold on.
a
Commissioner Torbett.
kind of along the same lines of your question, DJ, is can you just give us a little bit more information about why you felt like that the escrow money didn't need to be returned? I think that was also what you were asking, right, DJ?
Right, yeah, like, did you feel like you were owed that? Why did you take it and have?
I did not, as I said in my statement, that I'd filled out and sent in. Actually, we sent all this stuff in September, middle of September, I think. Cole can testify to that, Mr. Braun. But I admit that I did, I admit that I did wrong. It was a bad time in my life. I have no excuses. I feel like in my sense, I've been punished, for 8 years. I waited until 8 years to come back to just, I've done things in my life to help rectify it. I live every day trying to figure out how to do things better. So I admit my wrong. I admitted it back then from the date that they revoked my license. And I'm just, I'm on your mercy to, give me another opportunity.
I have a question.
Commissioner Smith.
Should the money have been paid through the recovery fund? Isn't there a system where that money is returned by the person that you paid that money for? Is that correct?
Yes, that's my understanding of the recovery fund.
So, so if that money was paid to Mr. Patel in his behalf, he should have received notification?
Yes. And then to be licensed again, pay that money back.
Okay, thank you.
Just ask him if he received notification.
But we can't compel the recovery fund to pay. So he had to Mr. Patel would have had to ask, correct? Is that what I'm hearing from you? And it sounds like he didn't. So
Yes.
going forward, I mean,
And if I'm not
we have
mistaken, a
no
judgment-
responsibility.
Mr. Dixon, did you receive notification that Mr. Patel had received payment from the Real Estate Education Recovery Fund?
I did not that I recall. No.
And I don't see any circumstance in which that he would not be notified, because it is a statutory requirement that if it's paid out for a particular individual, that they would have to pay the account back.
How does E&O figure into this, or does it?
I mean,
Who would have?
anybody can make a claim to an E&O insurance if at that time, but that wouldn't really be in
So-
our discretion. It would be something outside that they'd have
But that
to do.
could have been something Mr. Patel could have
It is
gotten some
option.
money from the E&O.
No.
Correct?
No?
No.
No?
Fraud?
No.
Doesn't cover?
Okay,
Doesn't cover
then,
fraud.
then no. There's also civil avenues too. There are lots of different avenues in which an individual can obtain that money back. And the unfortunate thing that we don't have here is and it's not necessarily unfortunate, is we don't know what Mr. Patel was thinking at that time, why he did or did not choose to receive that money or not. And making any kinds of assumptions or speculation about it, I don't think would be appropriate.
So it seems to me that there's 3 avenues that we could go here. We can defer and want more information. I don't know how much more information we would get, but we could do that. We can issue an affiliate license, or if we feel like, we can restore his broker license. But it doesn't seem like that's likely. But floor is open for a motion if somebody would like to make it.
I'll
You
make
could
a
also
motion.
choose not to issue a license at all.
I'll
So
make a
there's
motion
4
that we allow them to have an affiliate license.
All right, so we have a motion by Commissioner Gahn to issue an affiliate license to Mr. Dixon, seconded by Commissioner Tucker. Any further discussion, Commissioners?
Yes. I have
Ms. Smith?
Yes. If that's the vote, can we make a stipulation that he cannot apply for a broker's license, that he only has an affiliate license, or not?
I don't think so. Because the law permits an individual after 3 years to upgrade to be a broker.
Would it be automatic?
What do you mean? After it
He
would,
wouldn't come back before us. Once he's done 3 years as an affiliate broker, passed the broker's exam, he can get a broker's license.
right, that's what the law says at this point.
And we have no recourse there.
I don't believe so.
Thank you.
If there's no further discussion, let's vote. Again, all of those in favor of the motion?
Just 1 second.
Ms. Smith?
It looks like DJ is hesitant here. Would you like to say something?
If you guys could speak into your mics, Commissioner Moffitt, if you would turn off your mic to allow.
I didn't have anything, Commissioner Smith.
The suggestion has been made to do a roll call vote. I go ahead and, if there's no objection, we will go ahead and do that. Again, the motion is to issue Mr. Dixon an affiliate license. Commissioners in favor of that would say aye. Those opposed would say no. Ms. Baker, will you do a roll call, please?
Yes. Commissioner Gahn?
Yes.
Commissioner Tucker?
Yes.
Commissioner Smith?
No.
Commissioner Gwynn?
Yes.
Commissioner Torbett?
Yes.
Commissioner Moffitt?
No.
Vice Chair Vice Chair Ferris?
Yes.
Chair Diaz?
Yes.
The ayes have it. 6-2.
So, Mr. Dixon, that motion carries. 6 ayes, 2 noes. Congratulations, sir, and good luck to you.
Thank you.
Thank you very much for your time.
All right, well, that was a healthy conversation, Commissioners. Well
That
done.
one bothers me.
Didn't linger long.
No? All right. Next item on the agenda is the education report.
Sir?
Oh, wait.
If we could go back to candidate D, Crystal
Oh,
Kemp,
That's
and
right.
broker Dwight Price.
Ms. Kemp, are you with us?
Thank you for your patience. She is before us today due to a theft charge. She has taken and passed the affiliate broker exam. She will find her statement and letters of recommendation on your iPad.
All right, hold on, Ms. Kemp, let me get caught up here. Is she online? Do I see her?
Yes, she's right there. Once she speaks, you'll be able to
Okay.
hear her.
All right, Ms. Kemp, please go ahead and explain the circumstances that caused you to
see her.
appear before us today.
Well, I had a few years that were not the best, and I had a problem with prescription pain medicine, and I have been to treatment, and I have left that behind me. I've been a contributing member of my community for a long time. I made all restitution regarding the theft, and it was very out of character, and I would never dream of doing anything like that ever again. But I am accountable for that. And yeah, I've been in recovery for years, and I'm grateful for that. And it's taught me a lot, and it's made me the person that I am today.
Thank you, ma'am. And the principal broker is right there. Sir, go ahead and make your statement, please, sir.
Yes, sir. First of all, we apologize for the technical difficulties, but I think we're educated now. So it's a very active member of our community. She's been a personal friend for a long time. She and her family have high standing in the community. They're hard workers, good citizens. I look forward to having her on my team here at my office. She will contribute greatly, I think, to our buyer's agent program. And I just ask that you reinstate her license or grant her the original license.
Thank you, sir. Commissioners, any questions for Ms. Kemp or her broker? Hearing none, is there a motion?
Motion to approve.
I have a motion to approve by Commissioner Torbett, seconded by Mr. Gahn. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, ma'am, and good luck.
Thank you very much.
Does that conclude our informal appearances?
Yes, that now concludes our informal appearances.
Thank you
And
so much.
luckily, we have no waiver requests today.
Thank you.
Chairman Diaz, I have one question that one of the candidates that we approved, the probation period wasn't going to be over till January of '25. Are we okay doing that? Okay, that's all I need to ask.
All right, so let's keep moving here. We'll move on to the education report. Ms. Baker, I think that's you.
Yes, I'll be giving the education report today. Before you, you have a list of 45 courses for approval. We have reviewed all the courses internally and submit them for approval. Courses 0 through 45.
All right, so the education report has courses N1 through N45. Are there any courses that commissioners wish to pull out and discuss further? Hearing none, is there a motion?
Second.
I'm going to assume that's a motion to approve the education report, courses N1 through N45, made by Commissioner Smith, seconded by Commissioner Torbett. All those in favor of the motion, please say aye. Aye. All those opposed? Hearing none, that motion carries unanimously. Now, next is instructors. I think you have 7 for us.
There should be 11, excuse me, there should be 17.
17?
Yes.
Oh, looks like I didn't turn a page. Is that just a bunch of new applications or renewals that came in?
These are all brand-new instructors here to the state of Tennessee.
Okay.
Some have once had a instructor license and it was expired, so we're presenting them again before you today.
Okay. Commissioners, do we want to pull any of these applicants for further discussion?
Motion to approve.
Second.
I have a motion to approve by Commissioner Gwynn, seconded by Commissioner Tucker. All those in favor of the motion, please say aye. Aye. All those opposed? Hearing none, that motion carries unanimously. We also have discussion about the Bill Toon Award.
Yes, so yearly we give a Bill Toon Award. Last year, the awardee was former chairman of TREC, Marcia Franks. And so I wanted to open discussion if you guys wanted to give an award for 2024.
Commissioners? Is the award limited to licensees?
I don't believe it says in statute or rule that it has to be given to a licensee.
No one knows Bill Toon or anything about this award. So, no, there's nothing in the law or in rules related to the
We
award.
know it's a very
Anna, you were just saying
honorable award.
anything today, aren't you?
Yeah, let's-
No, I mean, if you've been on this commission, there's been a running joke about Bill Toon and knowing this person. I don't know who it is. So that's the only reason I brought it up.
I'll have the new director of education research the matter and have an update for you guys in February.
So can we open the floor for nominations?
Yes.
Is that what you're asking for?
Yes.
Yes.
So I would like to nominate Ross White.
Second.
All right, so we have a nomination to award the Bill Toon Award to our former education director, recently retired, Mr. H. Ross White. It was made by E. Ross White. Motion was made by Commissioner Smith, seconded by Commissioner Ferris. Any further discussion? Hearing none, let's vote. All those in favor?
Aye.
Any opposed? Hearing none, we will award Mr. White the Bill Toon Award for 2024.
Thank you all. We'll get that prepared and get that
Chairman.
to him.
Mr. Gwynn?
I've got a request on the Bill Toon Award. Could you just put us together a sheet that gives us a synopsis, who past winners are, how far back does it go? Is that possible or not?
If you allow me to get that for you in the February meeting.
Yeah,
Because we
yes.
have
Yeah,
a
whenever
robust
it is.
agenda
Yeah.
for December.
Yeah, however long it takes.
All right,
Okay.
thank you.
Ms. Baker, your turn again with the Executive Director report.
Thank you. There is a typo in my report. If you go to the exams taken by license type, you will see September 1st through September 30th. That actually should be October 1st through October 31st. So that will be updated on the report
Next month.
that's on file. Does that need a motion? It doesn't need a motion. All right, I have a few updates for you guys.
Go ahead.
In reference to the Director of Education vacancy, we received 42 applications for the position. Interviews took place over the past 2 weeks. We have recommended a candidate to TDCI leadership, and once approved by TDCI leadership, the candidate will then need to be approved by DOHR. We hope the candidate selected will be able to begin in December, and their first report to you all would be in February of 2025. It was a very, very impressive slate of candidates, and we think we selected the correct fit. I don't want to say anything on the record in reference to the candidate because it still needs to be improved internally and by DOHR.
Okay, thank you.
All right. Ariel, Carter, Kim Cooper, and I attended the Arello Regulatory Investigation Seminar in October. We learned about investigation techniques, testifying techniques, report writing, and we went through several case studies for around the country. So thank you all for allowing us to attend that investigation seminar. Lastly, TREC released its fall newsletter on November 4th. The newsletter had an open rate of 60.8%, which exceeds industry standards. The newsletter focused on TREC's E&O insurance provider and the renewal period, and that the renewal period does expire January 1st, 2025. So those that are listening, please renew your E&O insurance if you use the state provider. We also had in the newsletter a legal update in reference to the rulemaking hearing today and the rulemaking hearing in December. And lastly, included in the newsletter were announcements in reference to course and instructor renewals for the 25-26 period. You will also see financials in my report, and if there are no questions, that will conclude my report.
Ms. Baker, are you able to tell us about the high school program?
We will be giving a comprehensive update on that program either in December or February, since we're a person down and I've been assuming the duties of the Director of Education. That has not been a focus. However, we do anticipate a full report and debriefing on that program either in December and or February. We're still gathering data for that, but we have had several students complete the program, and at the end of this month, we'll conclude the majority of the 6-month period that applicants had to complete the coursework. So we will gather that data and most likely present it in February, but hopefully we will have a few data points in December as well.
So will one of those data points be the number of students that completed the program?
Yes.
And then were issued a license?
Yes.
Okay. Thank you.
Yes.
I've got a question back on your report. On the open and closed complaint report, do we have like a tally of, or an inventory of like what's open at any one time?
Yes.
Or we do?
Yes, there are probably over 100 open complaints. I meet with the legal team quarterly, as well with the assistant commissioner, to get updates on every single open case that we have with licensees and unlicensees or unlicensed activity complaints.
So if
that
you're
we have
looking,
open.
if you're looking at the report, and let's pick the month of August, we opened 52, we closed 4, and we sanctioned 8. So to make that number, the 52, 0, I mean, those two columns, they all have to add up, right? The only way to get it out, or is that wrong?
No, they don't necessarily have to add up. So a complaint is open. It could take 2 to 6 months to close that complaint. It can take up to a year to close a complaint. So those numbers won't necessarily add up. What you're seeing are cases or complaints that were actually open. The
Right,
closed
but I mean,
complaints are they've been either closed by you all, or they were closed because of lack of jurisdiction. There are a variety of reasons that a complaint is closed. And then sanctions are what you all give on any given commission meeting day.
So I'm just trying to get a feel, are we building up, are we maintaining, are we reducing, or what are we doing?
There's an opportunity to close more complaints, but that would require more hearings, and we can't get our licensees to necessarily agree to hearing dates. And so we're going to make a concentrated effort in 2025 to get some of these numbers down as far as our open complaints are concerned.
You think it would be good to have that on the report, like, or is that possible? Meaning, you know, you open so many, you close so many, you sanction so many, and so the balance is X. Or
I
is that-
can
is that a
see
bad
if
idea?
our IT can build that within the system to see if we can have a line item of total complaints opened.
Yeah.
Yeah.
Okay.
You may not see that on the December meeting,
Yeah,
just because we have a robust agenda, especially
That's fine.
since the bulk of our rulemaking hearing is in December, but expect to see that sometime in February.
Okay.
I have a question.
Yes.
I had
Thank you.
someone contact me and mention that the complaint process sometimes was a little difficult. I haven't gone through that process, so I don't know. Have you ever heard that before?
What's that mean?
I don't know what that means.
Well,
I think
I'm-
the reason they said that is because they had filed a complaint, put their name on it, had all the information, and it was a good period of time before they got a response.
So, I mean, the complaint process, we have, any individual it can take up to 180 days. So if we get complaints, we do get, pushback related complaints about how long they take, but it depends on volume, what the individual, how it's been presented to the commission. So sometimes it does take a little bit of time. Also, if it's a complainant, the complainant, it will be notified when the complaint is closed. So if the complaint is still one of those complaints that's open, it may be longer than that time period that they received notification.
Is dismissed and closed the same thing?
Yes,
Thank you.
it is.
So if they received a letter, said this.
Right, you will
number
receive a
was
letter.
Dismissed or closed or whatever.
And we oftentimes, if someone is disgruntled related to the complaint being closed or dismissed, they will reply back to us and we will do our best and reply back to them. But at some point, we still do have individuals that are displeased with the process, and we can only do as much as we can.
Thank you.
And I do have a brief update on the Bill Tooner Award. Thank you to the team at TREC that is listening. Thank you, Rihanna. The Bill Tooner Award for Excellence in Education is presented to individuals who represent the highest ideals of dedicated service and professionalism in real estate education. So thank you to the team that is listening.
And was first awarded in 1996 to Bill Toon. I believe he is, according to court, a deceased broker. Yes.
Commissioner Gahn, will you please state that on the record?
He was a broker here in Nashville that did a lot of education
Thank you.
back in the day.
Yep.
Okay. Ms. Baker, that concludes your report?
Yes.
Thank you. All right, now the public comment period. Has anybody signed up to take advantage of the public comment?
One moment, let me check. If we could have a moment to check that no one has signed up online. I don't see any names online that have signed up for the public comment period. And there is no one in the audience or that has signed in for public comment. So I think it would be fair to close the public comment period.
With that, the public comment period is closed. Do we want to push through the rulemaking, commissioners, or do we want to take a break? All right, we will take a 10-minute break. Please reconvene at 10:25. Thank you.
Thank you.
We are in recess. All right. Thank you, everybody. I'm going to call us back to order. I believe our next item on the agenda is the rulemaking hearing. Ms. Matlock, I think that's you.
Yes, that would be me.
When you are ready, please.
Ready? Okay. This rulemaking hearing is called to order. My name is Anna Matlock. I serve as an Associate General Counsel in the Department of Commerce and Insurance Division of Regulatory Boards, and I represent the Tennessee Real Estate Commission. Would the agency representatives who are present introduce themselves for the record? No, you can just.
Hi, my name is Denise Baker. I'm the Executive Director for the Real Estate Commission.
And if the commissioners will just state your name.
Steve Gwynn.
John Moffitt.
Joan Smith.
DJ Ferris.
Jeffrey Diaz.
Stacy Torbett.
Kathy Tucker.
Mike Gahn.
Thank you. Today is Wednesday, November 13th, 2024. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1B, Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and also available by electronic means via Microsoft Teams, which can be located on the program's website, www.tn.gov/regboards/TREC/meetings.html. On this page, the link for access to this rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the web page, in the row with the date 11/13/2024, in the location column under the words Davy Crockett Tower, Room 1B, 500 James Robertson Parkway, Nashville, Tennessee 37243. Labeled Registered to Attend. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee Real Estate Commission. The proposed rules amend the requirements for reinstatement of a lapsed expired license and temporary retirement following the passage of a new statutory provision and Tennessee Code Annotated Section 62-13-318 by the General Assembly. Specifically, the rules set the statutorily permissible penalty schedule for those impacted expired licensees and clarify the requirements for reinstatement, including those for continuing education. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and the adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Please listen carefully. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet on the podium to my right. Those members of the public wishing to speak and appearing via Microsoft Teams should place their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet and type their name in the chat box. Is there anyone else that desires to offer to oral comments but has not written their name on the sign-in sheet or typed their name in the chat box? For those attending this hearing in person, I would call your attention to the table by the door to the right of me. On this table, you will find red line copies of the rule amendments addressed in today's rulemaking hearing. For those attending via Microsoft Teams, you will find a link in the chat box to the red line copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearing included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on September 9th, 2024. Ms. Baker, what additional notice was given to the affected individuals or groups?
Information for the time and location of the hearing was placed on the program's website. An e-notify was sent to all licensees signed up for the program system on September 10th, 2024. And lastly, it was also placed in the TREC newsletter, emailed to all licensees on November 4th, 2024.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will summarize the substance of the proposed rules into the record. Rule 1260-01-.21, reinstatement of an expired license of a broker, affiliate broker, timeshare salesperson, or acquisition agent, paragraph 2, subparagraph A, Part 2, subparagraph 2, is amended by deleting the text, but within 1 year, so that as amended, the text shall read. Rule 1260-01-.21, reinstatement of an expired license of a broker, affiliate broker, timeshare salesperson, or acquisition agent, paragraph 2, is amended by creating a new subparagraph C. Rule 1260-01-.21, reinstatement of an expired license of a broker, affiliate broker, timeshare salesperson, or acquisition agent, paragraph 3, is amended by adding new subparagraphs A, B, and C. Rule 1260-05-.12, continuing education, paragraph 3, is amended by deleting the text of subparagraph A and B and substituting certain language. Rule 1260-05-.12, continuing education, is amended by creating a new paragraph 5. Ms. Baker, were any written comments received by the Commission office for the rule amendments that were not forwarded to me prior to today's hearing?
No.
As I have not received any written comments received via email prior to this hearing, I will now solicit comments from individuals present at today's meeting, either in person or via Microsoft Teams. Seeing that there are none, I will now conclude the comment period for the rulemaking package. Lastly, there are several measures that will need to be read into the record as required by Tennessee Code Annotated Section 4-5-222. First, I will need a motion to adopt the hearing rule language as presented.
Is there a motion?
So moved.
Have a motion to adopt the hearing language by Commissioner Ferris, seconded by Commissioner Torbett. All those in favor, please say aye.
Aye.
All opposed?
Sorry, hold on one second. We need to do the votes by roll call. Apologize.
Okay. We will do the votes by roll call instead of voice vote. Ms. Baker, when you are ready.
I will now call the roll. I will now call the roll for the rulemaking hearing. Chair D, or roll call vote, excuse me. Chair Diaz,
Yes.
Vice Chair Ferris,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Torbett, Commissioner Gwynn,
Yes.
Commissioner Smith,
Yes.
Commissioner Tucker, and Commissioner Gahn.
Yes.
Thank you.
Next, I will read the regulatory flexibility addendum. Pursuant to TCA Sections 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small business. The prompt states, to the extent to which the rule may overlap, duplicate, or conflict with other federal, state, and local governmental rules. Response, the rule amendments do not overlap, duplicate, or conflict with other federal, state, or local government rules. Prompt, 2, clarity, conciseness, and lack of ambiguity in the rule. Response, these rules are written in clear and concise language that is generally understandable. Any rule with language that is specific to the real estate industry is understandable to all of those whom the rules affect. Prompt 3, the establishment of flexible compliance and reporting requirements for small businesses. Response, the commission does not anticipate a need for the establishment of flexible compliance and reporting requirements. Prompt 4, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. Response, the commission does not anticipate a need for additional friendly schedules or deadlines for compliance and reporting requirements for small businesses. Prompt 5, the consolidation or simplification of compliance or reporting requirements for small businesses. Response, the commission does not anticipate the need for consolidation or simplification of compliance requirements for small businesses. Prompt 6, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. Response, the commission does not foresee the need for the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. Prompt 7, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. Response, the commission does not foresee the proposed rules will create entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. I will now need a motion to adopt the regulatory flexibility addendum.
I have a motion by Commissioner Smith, seconded by Commissioner Tucker, to approve the regulatory flexibility addendum. All those in favor of the motion, please say aye. Aye. Oh, I'm sorry, we got to do a roll call, you said. Okay. Instead of a roll call vote, a voice vote, we would do the vote by roll call. Ms. Baker, when you are ready.
Chair Diaz,
Yes.
Vice Chair Ferris,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Begley, Commissioner Torbett, Commissioner Gwynn,
Yes.
Commissioner Smith,
Yes.
Commissioner Tucker, and Commissioner Gahn.
Yes.
Thank you. The ayes have it.
I will now read the impact on local government statement pursuant to TCA Section 4-5-228. The response, the Tennessee Real Estate Commission foresees no impact on any local governments. I will now need a motion to adopt the impact on local government statement.
I have a motion by Commissioner Gwynn to approve the impact on local government statement, seconded by Commissioner Moffitt. This vote will be done by roll call. Ms. Baker, when you are ready.
Chair Diaz,
Yes.
Vice Chair Ferris,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Torbett, Commissioner Gwynn, Commissioner Smith, Commissioner Tucker, and Commissioner Gahn.
Yes.
Thank you. The ayes have it, 8.
I will now
To
read
0.
the answers to the questions required by the Joint Government Operations Committee. All agencies upon filing a rule must also submit the following pursuant to TCA Section 4-5-226I1. A brief summary of the rule and a description of all relevant changes and previous regulations effectuated by such rule. Response, the proposed rules amend the requirements for reinstatement of a lapsed expired license and temporary retirement following the passage of a new statutory provision and Tennessee Code annotated Section 62-13-318 by the General Assembly. Specifically, the rules set the statutorily permissible penalty schedule for those impacted expired licensees and clarify the requirements for reinstatement, including those for continuing education. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. Response, Governor Bill Lee signed Public Chapter 734 that goes into effect on July 1st, 2024. Following its passage, these rules were necessary to reflect the statutory amendments passed by the General Assembly. There are no known federal or state laws or regulations mandating the promulgation of these amendments. C, identifications of persons, organizations, corporations, or governmental entities most directly affected by this rule and whether those persons, organizations, corporations, or governmental entities adoption or rejection of this rule. Response, the rule amendments affect current and future licensees as well as applicants. The commission anticipates proponents of the rule amendments to include current and future licensees as the amendments positively impact those within the industry. As most of the rule amendments impact a small and specific segment of the licensees, the commission does not foresee a segment of opponents to the amendments. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. Response, there are no known opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. E, an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. Response, there is no foreseeable probable increase or decrease in state and local government revenues and expenditures. F, identification of the appropriate agency representative or representatives possessing a substantial knowledge and understanding of the rule. Anna Matlock and Denise Baker are listed. G, identification of the appropriate agency representative or representatives who will explain the rule at the scheduled meeting of the committees. Their response, Anna Matlock and Denise Baker. H is requesting office address, telephone number, and email address of the agency representative or representatives who will explain the rule at a scheduled meeting of the committees. The response is my information and Denise's information. And I, any additional information relevant to the rule proposed for continuation that the committee requests. The answer is not applicable. I will now need a motion to adopt the additional information for the Joint Government Operations Committee.
I have a motion by Commissioner Smith to approve the responses to the Joint Government Operations Committee, seconded by Commissioner Moffitt. This vote will be done by roll call vote. Ms. Baker, when you are ready.
Chair Diaz,
Yes.
Vice Chair Ferris, Commissioner Moffitt,
Yes.
Commissioner Torbett, Commissioner Gwynn, Commissioner Smith, Commissioner Tucker, and Commissioner Gahn.
Yes.
Thank you. The ayes have it, 8-0.
That concludes the rulemaking hearing. Following the hearing, the rules will be put on rulemaking filing form SS 7039, submitted to the governor's office for final review, and then submitted to the Attorney General's office for review and approval. Once the Attorney General's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today.
Okay. Do we want to pause to allow the court reporter to depart? Or, okay. Very good. I guess that, yes, ma'am. We will go ahead and proceed with the legal and consent agenda. There were 61 cases presented to the commissioners for this hearing. Of those cases, we pulled the following. Cases 7, 14, 17, 18, 19, 23, 26, 33, 34, and 39. Are there any other cases any commissioner would like to pull? Hearing none, is there a motion to approve the legal consent agenda minus those cases read into the record?
Make a motion, we accept the agenda with the exception of the numbers.
I have a motion by Commissioner Smith to accept council's recommendation in all of the cases minus those read into the record, seconded by Commissioner Moffitt. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 7, I pulled that one. Ms. Cooper, I have questions about a difference. So this firm is a real estate firm, and that is the license that they have.
Correct.
Would they need a license as a vacation lodging service that is distinct from a real estate firm?
In discussions with Ms. Matlock, we came to the conclusion that the vacation license, vacation, what is it called? I'm blanking on it. Vacation lodging service.
Lodging.
It was a block, sorry. That the statute exists for a reason. It has it has different requirements from a firm license.
Okay.
And that if the legislature did not want them to have it, that they wouldn't have specified the requirements that they did. I was pleased to see that you all wanted to discuss this because I'm of two minds here. We have a lot of, which I don't think existed at the time the statute was passed. We have a lot of corporate housing. We have a lot of agencies that are renting out for more than 14 days and therefore would need the broker and the firm license, which is why this organization did what they did. I can see their reasoning as well, because they are renting out properties for over 14 days. So I defer to the will of the commission as to whether or not this is unlicensed activity.
Okay, so you quote 6213-104B2, that's the unlicensed activity statute?
For vacation lodging service,
For
yes, sir.
vacation lodging services. All right, that's all the questions I had. Council's recommendation was to assess a $1,000 civil penalty for a violation of the code 6213-104B2. Floor is open for a motion. Or
So
questions.
would you say it's confusing to this person that whether they needed that license, or since they already had one, then they switched to the broker? Were they just confused about what they needed to be able to operate as they're operating?
I would say yes. I don't think it was an intentional, but they were hung up on, for lack of a different term, the same thing that I am hung up on, in that they do rent properties for over 14 days. And so they figured that was the trigger into needing the firm license as opposed to the VLS license.
So the way council has interpreted the statute is that if you're going to do rentals that are less than 14 days and in excess of 14 days, you need to have a VLS license and a broker's license.
Again, I would defer to the commission. Because there are different requirements for both, I would hesitate to say definitively that they don't need the VLS license. There's different training, there's different requirements. So I don't want to give legal advice to anyone listening, but on the side of caution, I would probably get both if I'm going to rent properties for over 14 days. But again, I can see where they felt like they were doing an abundance of caution by getting the firm license.
I think some consideration to the fact that this firm doesn't have any history of complaints might weigh on how we proceed here. We could do a letter of instruction as opposed to a civil penalty, but commissioners, I leave it up to the rest of you to make a motion.
I guess, just to reiterate what I'm thinking, so to get the VLS license, there's additional education and training versus just a firm license.
It's not additional, it's actually less onerous than it is to get a firm or a broker license, and it specifically says in the statute that if you have this VLS license, you are not required to get a broker license, but it is a different kind of training and it does have different kinds of requirements. There's also ongoing education for any of the affiliates that are with you. So, and there's also the additional requirement for a VLS to have a designated agent that we can contact in case there's any problems.
Okay.
I think it's $1,000 is a little bit strong for somebody was trying to do the right thing. That actually, the license they got is more onerous to them than the one they had. Correct? I say onerous, more difficult.
There's a lot more
to it.
education requirements, yes,
Yes.
for the broker or firm license. Yes, sir.
Okay. So I don't know what's easier to do, a letter of warning or a fine of $100. I mean, I don't know. But I think 1,000 is a little bit strong.
I would like to just send a letter of recommendation that they continue with their VLS licensing and that they have a point of contact for their VSL business.
Is that a motion, Commissioner Cohn?
I will make that a motion.
You said a letter of warning?
No,
Letter of-
a recommendation,
Letter of instruction.
instruction.
Second.
And the license and information be done within a period of time?
I would defer to Ms. Baker on that.
How long does it take once a applicant is received by us? It usually takes less than 7.2 days. It depends if something is missing from their application. For example, we may need a zoning letter. There are a variety of other things that we look at for firm licenses, but our average as of last week was 7.2 days.
So 30 days would not be out of line.
No.
I'll add 30 days, to be done within 30 days.
So I have a motion by Commissioner Gahn to send a letter of instruction to this licensee for case number 7 to obtain their vacation lodging service license within the next 30 days.
Second.
Seconded by Commissioner Gwen. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 14 was marked as discuss. Ms. Cooper.
So in case number 14, the complainants were out-of-state buyers that when they went to the closing, there was a document there that had their signatures on it that they did not sign. They immediately withdrew from the closing and lodged this complaint. The respondent, in their response, admitted that they signed those documents without the buyer's permission. They apologized and are asking for mercy from the commission, and I'll withhold my thoughts on that. So that's why I asked for it to be discussed.
Did the property end up closing?
Not with these buyers, no, sir. And at the time that the complaint was filed, I should mention also that they had not yet received their earnest money back. I followed up with the buyers, and they have since received their earnest money.
I'm sorry.
Forging a signature is pretty strong.
And I would
So
remind the commission that you
it's-
recently had a case where there was that same issue, and
Yeah.
you all recommend revocation, and that will be one of the hearings we're having in 2025, so.
So is there any indication that this is an affiliate broker that did this?
Correct.
So they clearly did it without the knowledge of the principal broker, I hope.
I went and checked again in the response, because it was as I said, a lengthy response. And I do not see any mention of where they went to their principal broker for help or they were having a lot of issues.
Or,
Help me.
got a firm no saying, no, you can't
Correct.
forge signatures on documents?
None of that.
None of that. So there might be an opportunity, well, not an opportunity, but a requirement there as well for the principal broker. Commissioners, thoughts, motions? Anybody?
I'd like to make a motion that we fine them $1,000 for 62-13-403, and that also a letter of warning that this type of action could result in the revocation of their license.
You mean a civil penalty?
Civil penalty, yeah, I'm sorry. And an additional letter of warning.
Well, we can put that information in like the cover letter. There would be no
Okay.
reason to send both of them.
Okay.
So there is a,
Would you like to restate your motion, a civil penalty of?
$1,000.
hold on, so a motion's been made to issue a civil penalty of $1,000 for violation of 62-13-4034. That motion has not received a second.
Second.
Seconded by Commissioner Torbett.
Can we add some education to that?
You can make a friendly amendment, yes.
I will make a friendly amendment to that. What for
6.
6-hour core course not to be counted towards continuing education. And completed within 120.
Commissioner Gahn?
I'll accept that friendly amendment.
Okay. So the motion now is to issue a civil penalty of $1,000 for violation of 6213-4034 and to add an education requirement of a 6-hour core course not to be counted towards their continuing education and to be completed in 120 days.
Question as to the reasoning behind the education. It's not necessarily, it's just a penalty, it's another penalty, right? Because, I mean, no education is going to help on forgery. I mean, that's not a flaw in knowledge of real estate practice. That's common understanding of the law. You don't sign somebody else's name to something. I don't care whether you've had a real estate course or not.
Maybe they need a refresher course in that. I don't have a problem adding the education because I think sitting in class and understanding the importance of our profession is something that we need to make people aware of.
Well, he can take that class online.
Well, let's go ahead and vote then, Commissioners.
I'll just go on the record and say that that is pretty egregious. I can't imagine doing that.
Well,
Yeah, so that's just wow. But people make mistakes. I've made mistakes, so just had to get that on the record that if this licensee is hearing this and if this amendment goes forward, you are very fortunate, super fortunate.
Well, let's go ahead and vote and see what happens. All right, so again, the motion being considered is to issue a civil penalty of $1,000 and to require the completion of a core course, 6-hour core course, not to be counted towards continuing education and to be done within 120 days. All those in favor of the motion say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. All right. Case 17. Case 17 is Commissioner Smith.
Yes, I pulled that one because I was concerned because it said that the respondent walked the boundary with a complainant prior to closing and told the complainant that the property stakes were set up were accurate in representing of the property lines. So where did they get the information that the stakes were accurate? Was there a survey done? Is the respondent now a surveyor? I just had some concerns there. Any information you can give me?
The respondent, I believe, denied that they ever said you can rely on those lines. They did say, yes, we walked the property. Yes, they did. They both saw the survey lines, and the respondent asked if the buyer wanted a survey done,
right?
And they said no. And so the respondent said, I did what I could to keep them informed, but that they made no promises that they were accurate, just that that's what had been done, and the markers were still there.
Council's recommendation in this case was to dismiss.
I'm not sure. I think we need to be really careful when we assume that that's the line and we don't know if somebody's really moved it. Then we're kind of getting out of our lane because then we become a surveyor.
And inclined to survey though.
No, when the agent said that's the line,
I think the respondent is denying they said that. Did I get that right, Ms. Cooper?
Well, they,
Unfortunately, the respondent's response was very short.
Yeah.
But they said, we walked the property, the lines were visible to both of us. They asked the buyer, do you want a survey done? And they said no.
and they did provide a copy of the report, importance of inspections. I'm assuming signed by the buyer. It bothers me a little bit, but I'm going to suggest that we accept council's recommendation to dismiss.
So I have a motion by Commissioner Smith to accept council's recommendation in case number 17, seconded by Commissioner Torbett. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 18, both Commissioner Smith and I pulled that one. So,
You go ahead.
thank you. And this one, I just like to understand terms that I don't recognize. And you refer to something called the program in the last sentence of the narrative. Is that TREC or is that something else?
That's the TREC program, yes, sir.
Okay, thank you. That's all I had. Council's recommendation is to assess a $1,000 civil penalty for unlicensed activity. Commissioner Smith, go ahead.
My question was, does the broker get a penalty with this one also? No, that's a no. Okay, thank you.
Move to accept council's recommendation.
I have a motion by Commissioner Ferris to accept council's recommendation in case number 18, seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 19. This one, you civil penalty for not responding to TREC. I assume that is to TREC and not. Okay. Do we have any record of the affiliate filing a TREC 1 changing principal brokers at all? Because I think the principal broker you contacted said that they had no contact with this agent either.
Correct. And at the time that I checked when I was preparing the report, there was not one. Let me see if they've updated that.
The license has just expired.
Mm-hmm.
Yeah.
Yeah, they're an expired grace right now.
Actually, they just renewed the other day. And they are now affiliated with, is that a different firm? Yes, they are now affiliated with a different firm than the one where this took place.
Okay. So I think we've asked this question a number of times at a number of hearings about, licensees that don't respond to us. How do we, if we assess a civil penalty, how do we collect? So we've gone through that. I think last month we had quite a few revocations. I don't know if response to not responding to TREC was one of them, but the full spectrum of our disciplinary actions are available, commissioners. Council's recommendation was a $1,000 penalty for failure to answer a complaint.
I move to accept council's recommendation.
I have a motion by Commissioner Ferris to accept council's recommendation in case number 19, seconded by Commissioner Torbett. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 23 is me also. So the notes I have for this one was asking about something that was in the file for it, like there's no executed release form from the agency agreement. And specifically if because usually the agency agreements are bilateral, so it's the consumer and the agent. Can one ask to be released and have that be so, or do they both have to agree to release? I mean, it's called a mutual release, so.
The respondents stated that they initially agreed to terminate the arrangement. I'm assuming she's referring to the mutual release. But then after things kind of went sideways, that they decided not to release.
This appears to be a commission dispute. Is that correct? I'd move to accept council's recommendation.
Council's recommendation was to dismiss. Commissioner Ferris makes a motion to accept council's recommendation in case number 23, seconded by Commissioner Moffett. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 26 is Commissioner Smith. When you're ready.
My question on that was, will the complainant know that the penalty was for failure to respond? My question was, when you send that civil penalty, they know what the penalty was regarding, correct?
The respondent or the complainant? Because the answer is the same. Both will know why the civil penalty was issued. Yes, ma'am.
Okay, that was my only question. I make a motion, we accept council's recommendation on number 26.
I have a motion to accept council's recommendation of issuing a civil penalty for $1,000 for failure to answer a complaint, seconded by Commissioner Moffett. All those in favor of the motion, please say aye.
I'd like a discussion on that briefly.
Yes.
How do we rule on that when we do not adjudicate commission disputes?
We recommend the civil penalty because we're not getting into the commission dispute. If they had simply answered as they were required to do, this probably would have been a recommendation for dismissal, but they did not do what they're supposed to do. That's what the civil penalty is for.
Yeah. Okay, yeah. Well, I have been steadfast in that opinion, so call the vote.
So the motion to accept council's recommendation to assess a civil penalty of $1,000 for failure to respond. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 33 is also you, Ms. Smith. When you are ready.
Yes. This is where the sellers were still inside the home. So I wanted to know if there was a possession in writing. Did you have possession for sellers, or did the contract say possession at closing, or was there?
According to the buyers, it was possession at closing, and they had actually continued the closing in order to do that. Let me see if they, there was no right of possession after closing. But I will confirm. No, there was no signed agreement that they could be in the home after the closing.
Okay, and so you're suggesting a letter of warning to provide?
I quite frankly debated on that, especially because of the tone of the text messages that were going back and forth. I firmly believe that the buyer's agent saved the day here and managed to keep what could have been a bad situation from happening. And so I'm not exactly happy with the respondent, but if you all would like to do a civil penalty, I certainly would be fine with that as well. It's just, to me, it seemed like a situation that didn't need to happen if there had been better communication.
So if I suggest a $250 civil penalty, that would be for?
Reasonable skill and care.
Then my motion is a $250 penalty for reasonable skill and care.
I have a motion by Commissioner Smith to assess a civil penalty of $250 for failure to exercise reasonable skill and care in case number 33, seconded by Commissioner Moffett. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 34, Joan, that's you as well.
Okay, let me refresh my mind just a second. Oh, this one is where they signed a document, seller signed a document and was paid money, but then found out that they had a lien on their property. So the complainant was not provided a copy of the document, but later got one from the registrar's office. So I agree with the $1,000 penalty. Can we add education? And commission, help me out if we do. We've talked about these situations before.
Yeah. I don't think education. I think the penalty, at least, this is a predatory practice, in my opinion. And I think John Greaser sitting here, we could do whatever we want to do. And, I mean,
I'm not sure $1,000 is enough because they got $900 on the front end. So that's a wash. That's a price of doing business is what I hear in my ear.
I feel like anything less than, I'm not sure if I'm up to the point of trying to revoke the license, but I feel like much less than that is an opinion of buyer beware in Tennessee.
There is a suspension option.
Yeah, and that's just.
You'll.
So, but we don't have any documentation. We don't have any documentation that shows whether they had the right to put that 3% lien on their house or not. And I can't personally do something to somebody when I don't have documents to say whether they could or couldn't.
Well, and the penalty is, the penalty is for failure to respond. The penalty is not for something they did in the transaction.
I know, but I think DJ was going further with the penalty.
Well, and also, just to point out that the complaint is against the real estate firm. So if you suspend or revoke the license, you'll be possibly impacting other affiliates.
What happened with the closing flag? Nothing?
It could potentially be represented to you all.
The closing flag could be represented?
From 2023, what was that? That's the closing flag.
And my other question is, so $1,000 penalty for failure to respond. So let's say once they get the $1,000 penalty and they decide they're going to respond, would that come back before us once they respond?
It could, yes. That could be something that we represent to you all. It's happened in the past where they receive the civil penalty and they're like, hold on.
This case also is currently in litigation, where the complainant is well, I wouldn't say closing flag, I would say this one. I believe Ms. Matlock is looking it up, but for this one in particular, litigation monitoring might also be a recommendation. There's a lot of moving parts with this particular respondent that we might have more information as it works its way through the courts.
I'm assuming that the $1,000 penalty for failure to respond is typical. That can be adjusted or not.
You all have established a precedent of giving $1,000 civil penalty for failure to respond, which is the upper level of what the rules provide for
Okay.
that
Thank
violation.
you.
Yes, ma'am.
Can we add litigation monitoring?
Commissioner Torbett, will you?
Can we add litigation monitoring, or do we just wait and see if the $1,000 civil penalty gets a response?
And just remember that this whole time while we're doing this, they got a license and allows them to practice in the state of Tennessee.
Ms. Matlock, can we do both litigation monitoring and a consent order?
I don't think so, because litigation monitoring means we're not doing anything at the moment until the conclusion of litigation. And so if we're sending out a consent order, that would be directly contradictory. And, I can, if you give me one moment, tell you more about the close and flag on this case. I figured out who the respondent is.
Can we add to the civil penalty for failure to respond and give a different civil penalty in addition to the failure to respond? Or are we stuck with failure to respond since we have no response?
You have all your options on that. If you see that there's grounds for another violation,
That was
by
my
all means.
question. But she said we'd kind of set a precedence for the $1,000 for.
Well, we'd have to add another violation.
So while we're thinking about what else we could do, I've got a question for council. It says the complainant was not provided a copy of the document, but later obtained a copy. So they've got a copy of what they signed. Is that your understanding?
Their attorney does, yes, sir.
Okay. And
Maybe it's the lien, because I got it from the registrar's office.
Correct.
it's the lien.
Well, I think it might be both, actually. The agreement that was the underlying basis for the lien. It's the wrong case.
I've got a question when she finishes looking. Is the respondent the same person that holds the broker's license for the real estate firm in question?
The firm is the respondent.
Right.
I don't-
But who is not responding? The firm.
Or the principal broker. Nobody.
Neither
is
one.
responding.
Right, so
Correct.
usually like the principal broker responds on behalf of the
Firm.
firm. It doesn't have to be that person, but it has to be someone from the firm.
So it is the same person.
So
then.
the firm would have had to be the person, the entity that put the lien on, because an agent can't put a lien on a house for commission, because the commission is owed to the firm.
But the person signing the lien would be the broker. It's got to be the broker. So the broker,
In perpetuity, right?
It would depend on how their listing agreement is. And in the wording of the listing agreement, if I possibly brought you 2 or 3 offers and you rejected them for crazy reasons or whatever, and I've said I've done my job, I'm entitled to my commission, then you could do that. But you'd have to prove it in court. I'm sure you'd have to go to court.
So what they filed with the registrar's office was a memorandum of homeowner benefit agreement, which is both a agreement in not perpetuity, but for 40 years, that if the home is sold, that they get both they get the 3% commission, and it effectively places a lien on the home, because anybody who goes and does a title search, that's going to come up.
Are there any exceptions to how the homeowner sells that property? For instance, to a family member, to,
No. No.
So I can give you information related to the complaint that was closed and flagged before. So basically, the underlying complaint was very similar to this one, that the respondent believed that they had been exploited by the respondent related to their age, memory, and lack of access to resources and comprehension, and that the real estate firm that enters agreements with homeowners have the right to their exclusive listing agent if they decide to sell their property. The respondent stated that they don't believe that they pressured the complainant to sign the contract with them. And then at this time, it stated that, after reviewing the response, the counsel that wrote it stated they had concerns about the business model, but nothing that was provided in the particular information showed predatory practices in this matter. But it should be noted that our respondent has firms in various states that have ongoing complaints about the firm's business practices. So the complaint was based on the information. Counsel recommended that this matter be dismissed, but flag the firm. So we have had complaints against this firm before related to this particular model.
Is this a single practice firm, one licensee, or is there affiliates associated with this firm?
I think it's just one license here in this state, but they do have licenses in other states.
Is there any, I guess I could make a motion to revoke the license. Yeah, I'll make a motion to revoke the firm license.
I have a motion by Commissioner Ferris to revoke the firm license, seconded by Commissioner Moffett. Is there any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Motion carries on a 7 yes, 1 no vote. Commissioner Gahn voting no.
Is it I'd like to hear Mike's thoughts on that.
I just don't have anything in front of me that tells me that I should do that or could do that. And I'd rather have information that would allow me to do that before I would vote to revoke some license.
Thank you. Yeah, absolutely. Thank you, Mike.
I would like to correct my error from before. It does look like that this firm has multiple licenses in the state. Maybe 7
But we will revoke the license
for this
particular firm of all the firms in the state.
No. No.
No, well, I'm saying the license for this particular firm, the other
this, yeah.
firms will remain open. I hope that makes sense.
That are not in the state of Tennessee.
No, they're all in the state of
So
Tennessee.
it would be like a franchise, essentially. Okay. So there are
7 Acme franchises,
branches
and we're
of
revoking.
this firm in Tennessee.
Yeah.
So we would be revoking this one branch, which is why when I looked at it, there was only one other complaint, because I know there have been other complaints before, but I believe it was under a different firm license.
And how many licensees are in that firm? Just one? Or the
no.
one we just revoked, how many
I
licenses?
can look and see. Hold on one second.
I mean, there's nothing prohibiting us from changing that. If we all feel compelled to.
What happens to licensees when their
Right.
firm has been revoked?
They have to transfer to another firm.
So that means the revoking person, the person who got revoked has to sign their TREC form.
Mm-hmm.
That's going to be interesting.
Well, and it just to,
Right to come forward.
well, and to DJ Ferris's point, there would have to be a motion to reconsider, and that would have to pass before we can take up case number 3.
What if the licensee can't get the
again.
revoked firm to sign the TREC one, that is physically won't do it? Do you have to, what do? Do you make a motion to us, or do you go sue them, or what do you do?
It just submits an affidavit of release.
Who?
The licensee that wants to transfer, if you can't get the principal broker's signature, he submits an affidavit of release.
That says what? They tried and they couldn't do it?
They said you cannot get the signature for whatever reason. Yeah.
Okay.
So it appears that there may be 4 licensees, but we will look into this particular firm license and revoke that firm license.
Yeah, I don't know that I got that right. I kind of shirk at the business practice. I'm concerned how often that may or may not be happening. We're only hearing those who are wise to it and have complained. So I just wonder what other residents of the state have been affected by this unknowingly. Yeah, but
I'm also wondering, what do we do to the licensees that may be there that are doing what they should be doing?
yeah, there's a chance of that, I suppose, but it seems like this is I'm assuming, which is not best practice, but that the firm that's all they do. I may be wrong in that, but I do want to,
Got 2 complaints.
yeah.
So maybe these affiliate brokers need to be elsewhere.
And I feel like a letter of warning and a fine for not responding is just going to be just kind of
Just get their attention.
shrugged at. And, I'm thinking, I don't want to muddy the waters with this, but, within the past 2 or 3 years, we had a significant influx of complaints regarding timeshares, so much to a degree that Tennessee became one of the first states to alter how timeshares are done. And it's still not where it ought to be for consumers, to where it's a laughing matter among people. You don't do a timeshare, don't do that, that's a crock, whatever. But we had begun, and as we oversee the practice of real estate in the state, we've begun to better that practice. This is something that we closed and flagged in 2023. It's come up again, and it needs to be addressed or spoken to by this body. Like, I don't know. I mean, that's not deserving of a real estate license as I see it.
Well, and in addition to what we do here, there's also the opportunity to refer to the Attorney General's office for further action, because if they're franchises and they're all doing this within the state of Tennessee.
I want to correct the record. We did further review. There is one franchise here in the state of Tennessee, and they have 4 licensees that will need to go elsewhere. But you all have voted 7-1 to revoke that firm's license, and we will do that one firm license that's in the state.
Does anybody, I mean, I don't want to.
There was a technical error that was showing 7.
Did we get a copy, did you receive a copy, I should say, of the homeowner benefit agreement that they signed? And is it a real lengthy document? Is it pretty clear that the lien would be put on their house, or that they couldn't sell their house? I mean, is it?
It's 1 page.
Whoa.
I'm very happy with our decision.
I have no motion to reconsider at this time, and if these parties, these respondents, feel that we need to know otherwise, then they are certainly welcome to come and share what we need to know.
I agree.
All right, so we're done with case 34 then? Everybody happy? Maybe not Commissioner Gahn, but 7 of us are happy?
But we're clear, though, that we revoked a license for a firm, not for a broker, so that the broker that set the firm up can say, okay, fine, I'll just go set another one up, and that's what we're in a whack-a-mole kind of thing, right?
So the complaint was
For the firm.
for the firm.
So that broker can that broker can go open up another office.
And there's nothing we can do. It's the
Well,
way
they would have to apply for a firm license through TREC.
Right. Well, how can we deny that?
Those are good questions, Steve.
Yeah, real good.
I assume you could open a complaint against the broker, a administrative complaint?
We can. For what reason? Would it be, you'd have to cite statute or rule?
I would guess the honesty part.
Failure to act with reasonable due skill and care. I mean, I'm just talking here. I'd be of the mind to I can make a motion to reconsider our ruling on that case. That could be approved or support, that could pass, and then make another motion to revoke the license of the principal broker.
Well, we couldn't do that because we have to serve process. Yeah, so we'd have to.
So if I'm hearing correctly, and I'm sorry, I was talking to counsel, you want to open up a complaint against the principal broker, is that correct, or did I mishear?
That's what it was coming to, because I was prepared to do more, but correctly, we have to do it this way. Yes. So
what are you suggesting now?
That I make a motion to reconsider what we voted on in regards to revoking the firm license, and then open a complaint against the principal broker for lack of reasonable skill and care.
And then we would have to serve process and give them a chance to respond, and that would come back to us at a later date.
Why would we need to reconsider? I think we still could have the revocation of the firm license and open a complaint against the principal broker.
Yeah, it would just be a
Because I
second
want the
motion.
firm to quit doing what they're doing.
Right.
Regardless of
Right.
what happens to the principal broker. So if it takes
Right.
6 months or a year to start a new firm, that's 6 months to a year that this isn't gonna happen.
It probably wouldn't take him that long, he or she that long to get back in business, to Steve's point.
Let me ask counsel a question.
Can you use your mic, please, sir?
Was the same broker on the other complaint, the same broker?
Please allow us about 30 seconds to look up that information. It's in two different
Right.
screens that we need to get to. Yes, it's the same principal broker.
Well, I think we always should broke his license.
Can I make a motion to open a complaint against the principal broker?
Yes, ma'am.
I will make that motion.
I have a motion by Commissioner Torbett to open.
And this is on case 34.
Case number 34.
Okay, thank you.
To administratively open a complaint against the principal broker in case number 34, seconded by Commissioner Tucker.
And this is a complaint for what?
Failure to deal honestly with all parties.
All right. This is an opinion question. Does the complainant have the ability to use our decision in their court case?
That would be up to their attorney, whether they
But
want
if
to.
he tried, would that be admissible?
It could be in any lawsuit that they're going
could be,
forward,
right?
yes, sir. They can certainly mention it and submit proof of your decision here today and proof that there's also ongoing activity potentially against their licensure. Yes, sir.
But this commission does and has the ability to independently act from any other additional, like judicial matters that are going. So you don't have to wait for another court to rule before making a decision.
I wasn't suggesting that. I was
I know, I
thinking it
just
might
wanted
be better, make the complainant's case better to use our revocation in their lawsuit, but I don't know if that's.
Right, but that's up to their attorney's
Right.
strategy, and then it's up to the judge whether that information is admissible or not, like you're
Yeah.
saying.
Any further discussion on the motion?
Chairman and council, explain to me as if it's as very elementary as you can about why we could not vote to revoke the principal broker's license.
Because it's a due process issue, so they have to have notice of the complaint and an opportunity to respond. Right now, they don't have notice. So we can't move forward with anything until they've actually received notice of the complaint.
Right, so we have to have a complaint in order to do something first. And so at this time, the complaint is only against the firm, not against the principal broker. Correct.
Okay, thank you.
Let me ask you this. They have the 10 days, the typical 10 days to respond once they receive the complaint.
Yes, sir.
Is it, if they fail to respond, would an emergency hearing be in order so that we can then consider revoking that license or any other disciplinary action we'd want to pursue?
There are grounds in the APD to move forward with a summary suspension or revocation of a license. There are, the grounds are, one of them are public welfare, but there needs to be an immediate harm to public safety or welfare. I don't know that a failure to respond is going to meet that threshold. So I would suggest that we let the normal complaint procedure run its course instead of jumping to that option.
Would it be represented next month if they don't respond? Or would it be a few months?
The normal complaint procedure is that the complaint is sent out, they are given 10 days to respond. If they don't respond, then I believe they're at the 30-day mark they are told, you failed to respond within 10 days, you can still submit a response if you want to, but we've referred this to legal, and then it would come to legal. So it would, at the minimum, it would be probably 60 days. So the February meeting is when we would
Right.
get that.
And
Yes,
the
ma'am.
turnaround between November and December is always very tight, so I don't see it possible to get it on the December report, giving them the time for them to respond, the time for us to get the report in, approved, and to you guys before the meeting. That's just, we're lacking some days.
There's also a holiday in there with staff, so.
Yeah, Thanksgiving.
Okay. So the motion is to administratively open a complaint against the principal broker for case number 34. All those in favor of that motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Does anybody else want to do something on case number 34? All right, we will proceed to case number 39 then. And I pulled that one, so that one's mine. Let's see. So this is the video. And the question I want to ask is, who did the video? Was it the respondent or was it somebody else?
The respondent did the videos.
So the respondent did the video and saw theoretically that there was water stains and holes in the walls and all this other kind of stuff, and they didn't. Is the video supposed to be noticed to the consumer, to the buyer, or the seller that these things exist?
So essentially, the respondent was representing the complainant in this situation, so they're a buyer in this transaction. And so the complainant is essentially alleging that the respondent did not give a full representation of the condition of the home, although they sent videos, like multiple videos, to the complainant, who is their client at that time. So
Right.
it's like a bearing of opinion. So the complainant would argue that the respondent told them that there was minimal work to be done and that it's essentially okay to move forward on this case, like on this house. The respondent would argue that I've done my due diligence and I presented multiple videos. I believe they did 7 videos that they sent to their client, showing the property, along with like multiple text messages kind of discussing like, hey, thank you for sending the video, you're doing a great job. And then also they had a property disclosure form that was signed, so.
So
like,
and
just a
it sounds
disagreement.
like this might have been like an as-is kind of purchase?
I think they took it as is.
Took it as is?
I can't
Okay.
say for sure, but it appears it's probably like a fixer-upper that they were trying to buy, and
And they got
did
one.
like, and it looked like, based on the pictures of them, like the listing, it looked kind of. like we
Wish
fix it up.
granted, you got a fixer-upper. Okay, council's recommendation is to dismiss. Is there a motion?
So moved.
I have a motion by Commissioner Ferris to dismiss. Is there a second? Seconded by Commissioner Torvet. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. And by my count, that concludes the legal and consent agenda. Anything else? What else we got? We did commission, we did that. Okay. So if there's no other business,
I've got
I have-
something, yeah, go
I have
ahead.
one announcement.
Commissioner
Our
Baker.
next meeting is December 11th here at the David Crockett Tower. And then after the commission meeting that day, there will be a meeting with TREC staff and you all, much like what we did last year.
okay, okay, very good. DJ?
Thank you, Chairman. I wanted to draw attention to a timely, for this meeting, the passing of a former real estate commissioner and resident of Nashville, who was a friend of mine, and his name is Ray Tarkington. Ray was born in October of 36 in Nashville, passed away on October 29th this year. He's survived by his beloved wife, Janet Jones, who was a former broker of mine, and longtime practitioner in her own right. And survived by his daughter, Glenda, Raymond, Eddie Tarkington, several grandchildren. Ray was a Battleground Academy and David Lipscomb College, now Lipscomb University, received his certificate in real estate from the University of Tennessee. Ray began his career in 1959 after receiving his real estate license and was affiliated with several firms before opening his own in 1965. and now that is with Chris Harwell here in Nashville, and he was active in that firm until his death. Tarkington Harwell Realtors, a very esteemed company. They also own Mr. T's Patio. You probably saw that on 65 for many, many years. Ray was active in the real estate business for over 50 years. He served as president of the Greater Nashville Board of Realtors. In 1980, Governor Lamar Alexander appointed him to the Tennessee Real Estate Commission as a commissioner for a term of 5 years. He was involved in many civic and community activities, including Hospital Hospitality House, chairman and director, Team Challenge, president, Brentwood Gideons, trustee of Brentwood Academy and other community organizations. Ray also served 6 years in the 345th Army Infantry Reserve and was a founding member of Christ Presbyterian Church and the Stevens Valley Church, where he was a present member. So Ray was a fine gentleman, a great example of a Nashville native, a good broker, and loving husband, all that. And I thought a lot of him and Janet, and so we thank him for his service many years ago for TREC, and we are sad for the loss of Ray for his family. So thank you for allowing me to share that, Chairman.
Thank you, DJ. Anything else? Hearing that, we'll go ahead and adjourn until December 11th. Thank you, everybody. Please travel safe home if you're heading towards Memphis.
Thank you all.
Wherever you're going.